All right, we are live. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Massachusetts Appeals Court oral argument session. Our first case is Commonwealth versus Anthony Coleman, number 2019 P1239. My name is Justice Peter Sachs, and I'll ask my colleagues to introduce themselves now.
My name is Justice Sabita Singh.
Good morning, Wendlandt.
And Appellant's Counsel, could you please state your name and the party you represent?
Morning, Alexander Conley, and I represent Anthony Coleman.
And Appellee?
Good morning, Catherine Sullivan for the Commonwealth.
Thank you. As you know, this argument is being held on Zoom and live streamed to the Appeals Court's YouTube page. I want to remind all participants to speak slowly, clearly, and one at a time. We'll follow the same rules and customs as in the physical courtroom. Each side will have 15 minutes to argue. The justices will ask questions. Only one advocate may speak at a time. The session clerk will mute other advocates until it's your time to speak. The session clerk will display a countdown. This proceeding is live and being recorded, so anything said during the proceeding will be heard by all of those observing and become part of the record, just as in the physical courtroom. A pseudonym must be used for any person's name that's impounded, and impounded information must not be disclosed. And with that, I will ask Mr. Conley to begin for the appellant, Mr. Coleman.
Thank you, Your Honor. In the case against Mr. Anthony Coleman, there's essentially two issues that are brought up on appeal. The first one is denial of the motion to suppress, and the second one is the admission of what I would suggest is improper testimony as to an ultimate issue. I'd like to start by going through the motion to suppress issue. The initial motion to suppress filed in the trial court was relatively broad, asking to suppress everything, including the drugs that were allegedly found on the side of the road and the evidence that was seized from Mr. Coleman's person and from his vehicle. On appeal, that's slightly narrowed. All that we're talking about are the drugs that were seized from his person and his vehicle. Additionally, I think it's also been narrowed even further by the Commonwealth's brief, where they don't suggest that this is a case where there was a civil motor vehicle stop that transformed into a custodial arrest situation, citing in footnote 21 Commonwealth v. Beretto that that's not what we're talking about here. They also suggest in the brief that it's not a situation where this is a threshold inquiry based on reasonable suspicion either. Instead, what we're dealing with here seems to be pretty specifically whether or not there was probable cause based on the totality of the circumstances to have an arrest of Mr. Coleman and therefore the subsequent search and seizure of the evidence found in the vehicle and on his person. With that in mind, I would just suggest that the cases and arguments in my brief regarding reasonable suspicion also play into the analysis for probable cause, because while those cases in similar circumstances found not even reasonable suspicion, in cases like Commonwealth v. Rodriguez, therefore in a similar circumstance here, there would also show that there's not probable cause for the stop and arrest. With that in mind, I want to just go through some of the factors that are present here that could play into a calculus for determining whether or not there was probable cause or was not probable cause, as I would suggest. First, the most important factor that was not present here, and case law makes clear it's probably the most important factor often, is the actual observation of any kind of exchange. Here, there's no exchange observed. There's not even a hand gestures, nothing of the sort to show that, yeah, something was exchanged from one party to another party that led them to believe that a drug transaction occurred. The second thing that is not present here that's also very important is prior knowledge of either suspect. Instead, we have no idea. The police, when they see these two gentlemen in a car, have no idea who they are, what they're doing, anything about them. It's not a case where they ran their information, ran the license plate, that this people have been involved in numerous drug transactions. Nothing like that. They're two strangers just in an area. The next factor is the presence of where they're present, which is a high crime area, according to the officers who testified, to Detective Panakopoulos and Detective Emery. That's why it's a high crime area, essentially. At the outset of that point, I want to note that the judge's findings didn't mention a high crime area. It wasn't part of his actual findings. And I'd suggest because that's because much of the current case law and the trend is to suggest that the high crime area factor is not as valuable as it used to be considered, that people's rights shouldn't be diminished just because of where they are in the world, and that you shouldn't have a high, just because you're in an area that's a high crime means that you're a criminal isn't really proper. The next factor, which I think is kind of the linchpin factor here, is what they had thought they observed with the short drive. I suggest in my brief, and I suggest again that the way the judge determined this, that this was a short drive to nowhere, is actually an erroneous finding based on the evidence, because at the outset, they're seen, Mr. Coleman and the other individual, Mr. Gaines, are seen in a vehicle. They're not seen, nobody's seen getting, Mr. Gaines nor Mr. Coleman is seen getting into the vehicle. They were just both started in the vehicle. So we don't know how long this drive was, when it started, where it started.
But they were stopped. At the point that they were observed, they were stopped. They were not moving. Is that correct?
That's correct. They were parked in front of a marketplace. They weren't moving at the time, but we don't know if Mr. Coleman had been picked up or Mr. Gaines had been picked up at the marketplace, or if they had driven together to the marketplace, or where they came from before that. At the time the police first arrived, they were together in the vehicle. There's not even evidence that the car was on or off or what was going on with that.
Isn't the ride to nowhere significant anyway, even if the officers didn't see them or either of them get into the car, just they're parked, then they go around the block and they end up in the same spot?
I think it could have some significance. I think to have it have the significance that raises the level of probable cause takes a lot of conjecture and surmise about what that means.
Right, but we don't look at probable cause on each individual factor. So I'll let you go on with the other factors that were present.
Well, the only other thing I'd say on that is that in the way that they look at probable cause, especially through Santalese, you look at the silent movie of things. And in most of these cases where there's a short ride to nowhere, there's a pretty standard way this often happens. And one of the most important parts of it is the initiating part, where first a person is seen in a parking lot by himself, acting suspicious, making phone calls, things like that. And that's in most of these cases present that leads the courts to say maybe there's probable cause, maybe there's reasonable suspicion. Sometimes there's not. However, here we don't have that. We have only the second half of it.
Counsel, may I ask, when they got back from the ride around the block, Mr. Gaines got into or started to get into a truck, the engine of which was running. Couldn't the police consider that as evidence that they had just arrived, he and the woman in the truck had just arrived in the area a short time before and expected to stay only a short time?
It's certainly something they could have considered. There's no evidence the truck was there before. That wasn't brought in. The truck was only noticed to be there when they arrived back. It's equally likely that this could have been that Mr. Gaines was waiting for his ride to appear with Mr. Coleman. They drove around the block, and when they came back, the truck was now there and they could leave. Again, it takes a lot of conjecture, which I think falls short of probable cause in this circumstance, to say that because the truck was there, therefore it must have been a short ride, since we don't know when the truck arrived. And even subsequent to that, we don't have any evidence that the truck had just arrived, other than the fact that the engine was on now, or the truck hadn't just arrived. The other factors that are brought up is by the judge, especially, is the slowdown and turn on the other side of the road that Mr. Coleman makes, as well as the failure to stop the stop sign. As noted, this isn't a case where the failure to stop at the stop sign is the justification for the stop, but the judge and the officers believe that was something that added to their calculus of this is suspicious activity. I would suggest, and I don't think and in the Commonwealth's brief, they don't really raise this point as being something that's particularly important either, because this is very speculative, I believe, to say that, and the officers testify as much, they didn't really know what was going on, what this meant, what this turn meant, why he was doing it. That it would be speculative at best to say this is proof of a crime in any way or proof of criminal activity. I think that's way too speculative in that one. Then the final factor here, which I think is, I think the Commonwealth breaks this into two factors, but I've used it as one, is evidence gained through the stop of Mr. Gaines. Evidence, yes. Here we have the statements of Ms. White, the statements of Mr. Gaines. and the drugs that were seized, essentially. Basically, these pieces of evidence show, I would suggest at best, that Mr. Gaines had drugs on him. Mr. Gaines had bought drugs, and that Mr. Gaines, that's essentially what they have here. So you have to show Mr. Coleman's guilt by association with Mr. Gaines, which I think is not a proper way to do things any more than it's a high crime area.
Wasn't Mr. Gaines observed clutching something, leaving from one car, going to the other car, and also subsequently ditching it in the car?
He was observed having something in his hand. He had a clutched item in his hand when he left the car. Again, this goes back into the factor of what was seen before, whether he had those drugs before, we don't know, which is what differentiates this case from some of those other cases where I think it's somewhat be St. George, where there's somebody who's seen without a bag first, gets into a car, and then is seen leaving with a bag. So for this case, we'd have to conjecture that because he's clutching something, he must have got it from the car.
What
Or that
about
he just got it.
statement? Sorry.
Go ahead, Justice Wendlandt.
What about Miss White's statement that he was there to purchase?
He said that he had purchased drugs, I believe the statement was. He had just purchased, or he was there to purchase drugs, not for her, I think was her statement. I think this statement shows that he had purchased drugs, but it's not directly tied to Mr. Coleman or to the ride. There's no statements there about where the drugs were purchased, when the drugs were purchased, how the drugs were purchased.
I want to just step in on that. The judge found that the woman informed the officer that Gaines was there to purchase heroin, but as I read the testimony, she just said he was buying heroin. She didn't say he was there. I don't know if you think that's significant.
Yes, I'd agree, Your Honor. It was not specific that he was there at this place at this time for this purchase. He had bought heroin, and that was hard to say otherwise since he was found with heroin. Of course, he had bought it at some point in time.
But isn't it reasonable to infer that where he had it in his hand, he just very recently acquired it, versus he had some other, I can't remember what it was, but some other controlled substance in a pocket, didn't he?
I believe he had some other controlled substance. I believe it was in the car as well. Yeah, it's certainly an inference that could be made. I think it's an inference that would be permissible to make. However, I don't think it's an inference that, especially on top of all the other inferences, rises to the level of probable cause. Even if we were doing a reasonable suspicion analysis, it might change that a little bit. It might make a heightened level slightly over the hunch that would put you over the reasonable suspicion bar, but probable cause is a higher standard. And I think that would be an extra jump we need to make there. And I think there's another case, I think that one is also Commonwealth v. St. George, where they found that there was no reasonable suspicion. And I think it was actually Commonwealth v. Rodriguez, where there was the bag and he took the bag and was found with the bag after the fact. And they said there wasn't reasonable suspicion, but not probable cause, even though it was clear that the bag had come from the car, but it wasn't clear that there had been a sale in the car.
Counsel, you can allocate your time however you want, but you've got 3.5 minutes left. So if you want to cover your second issue,
Thank you.
At least you're welcome to move on.
I would just note very, very briefly on the last issue that there is, I suggest that Commonwealth would not be able to prove that if this was an error, that it was not harmless beyond a reasonable doubt, because even though the evidence seized was the money, the marijuana, and the knife, and not the heroin itself, that was very key evidence as to showing that he was a drug distributor and not just a drug user, or that he just had drugs. On to the second issue, as far as the opinion on ultimate issues here, I think that there was testimony from both Detective Panakopoulos and Detective Emery into saying that they believe the drug transaction had occurred. I think that in the case law, Commonwealth v. Woods, Commonwealth v. Tanner, and that their progeny, I think that it's clear that that is something that is an ultimate issue when a drug transaction case, in a drug sale case, to say that the drug transaction occurred.
Can you address the Commonwealth's argument that this was really part of a deal that was made? And that is that there was a motion in limine to preclude the expert who was a non-recipient witness. And the judge, in connection with that, had said, I'm not going to let the recipient witnesses testify as experts, but so you can have your expert, Commonwealth. And now instead, when they testified, the defendant didn't object. And so the judge said, well, wait, this is all going to become cumulative. I'm not going to let the expert in. And so this is a deal.
Right. I think that the Commonwealth's initial plan was to properly use a third-party non-precipient expert to testify. But however, when the testimony came out, it was the other way around. They used the precipient witnesses, and they did testify as the ultimate opinions. I think that the motion in limine nonetheless preserved that error, because even though it was denied for the reason that there could be some other witness testifying, it was clear that the defendants sought to keep out any testimony about aspects of the drug trade being consistent with any aspects of what happened to be consistent with the drug trade. And I think that this very squarely fits within that box. I think there was a little bit of a broker deal subsequent to that to not have the expert come in. I don't know if that really affects whether or not this would have been an issue, because the motion in limine all happened before this broker deal, and the objections or lack thereof all happened before this broker deal. That was subsequent to this, where the Commonwealth and trial counsel and the judge came to the agreement that there won't be any further objections to the recipient witnesses testifying. But that was all subsequent to this testimony coming in.
And you don't think that affects our analysis on substantial risk at all?
I think that because the motion in limine was so clearly asking for this exact kind of testimony to be excluded, whether by a precipient witness or a non-precipient witness. I believe the first line of the motion in limine is any opinion testimony by any officer concerning whether any observation was either indicative or consistent with aspects of the drug trade should be excluded. I think that squarely covers it. And when that motion was denied to have anybody do it, it covered whether or not, whether it's a precipient witness or Officer Foley. Is my time being expired unless there's any questions?
Yeah. Any further questions from the panel?
No.
All right. Thank you, Mr. Conley. Ms. Sullivan for the Commonwealth.
Good morning, Catherine Sullivan. Good to see you all, even this way. I'd like to address a couple of issues raised by the defendant this morning. Otherwise, I'll rest substantially on my brief, as it really refutes many of the issues he's raised. With regard to the first issue, it's clear that Officer Emery testified that that ride to nowhere that he saw took under a minute and went for less than half a mile. So there was a discussion about the nature of that. And certainly that, together with the fact that these were experienced officers who had made arrests at that specific address in the past, were well acquainted with the nature of an illegal drug transaction and what a ride to nowhere consisted of, in addition to the statements made by Mr. Gaines' girlfriend following the transaction taking place, all created probable cause justifying the stop of the defendant.
Can I ask you a question on the ride to nowhere? Do you have any cases where this ride around the block situation does not include an observation by officers of one or two parties coming to the car, into the car?
No, but so as with so many cases, I think we have to look at this, uniquely and add up all the factors. And as is usually the case, the ride to nowhere is simply one factor. I think that the fact that the drugs were, that Mr. Gaines threw, had something in his hand and threw it into the car immediately after, there was no break in the sequence of events from the officers seeing the ride to nowhere, then following Mr. Gaines, then following the defendant. Nothing interrupted that chain and sequence of events. In other words, if Mr. Gaines had gone somewhere else prior to Detective Emery stopping him, there may be problems with that ride to nowhere being as important as it was in this calculus, but where it was, excuse me, like, Santalese, we rely on it, but excuse me, it was like a movie taking place, and there was a distinct and discrete series of events, all that reflected the drug transaction leading to the stop and arrest. So I'm not sure that we need a case, on that specific point. And there are several cases in my brief that speak to the fact that no observation of the actual hand-to-hand transaction or sale, a transfer is required in the calculus.
But this isn't a traditional ride to nowhere. We have no idea when it began, how long they'd been sitting there, whether this was a brief interaction or a lengthy one. And we have no furtive actions by the participants either.
Well, I'm not sure that we don't know how long it took, because I think, as Justice Singh or someone said earlier, that the car was stopped. And we don't know when Mr. Gaines got into the car, certainly, but we do know that the car was stopped. And I'm not sure we need to know what transpired before the officers came upon the car, stopped, and then, saw the car leave, return to the same place. They followed it around the block. Like I said, there were no intervening actions by either, the defendant or Mr. Gaines or the officers. This was all one series of events. So altogether, when viewed through that lens, I think more than definitely, more than sufficient to ascertain probable cause to stop. And then, certainly Officer Emery's relating to Officer Panikopoulos what Ms. White said in the car, and what he found in the car, that he found heroin in the car, justified the stop. So, so as I said, if the sequence or the actions were, if there were intervening actions in any respect, then it might be a different case. But here, certainly it was a series of events and viewed the entire time by the officers. So,
well, we don't really know when the movie began, do we? Or from what the officers might have come in the middle of the movie.
Well, I don't think it's necessary to know what happened prior to the ride beginning. I'm not sure that that's a requirement for there to be a ride to nowhere.
Isn't what makes it suspicious the fact that it is a brief, that the ride to nowhere, in the cases that I'm aware of, is part of a brief encounter. And we don't know whether this was a brief encounter.
Well, we know that the ride itself was brief. I think that's the determining factor. The ride itself was a matter of minutes and went around the block. So we know that is clear from the record. And I think that's all we need for it to be the ride to nowhere. There certainly wasn't anything in the cases that I've read about this ride and, its characteristics. There was no testimony that they were on their way to somewhere, nor was there any testimony that they were on their way from somewhere. So for my thinking is that the analysis is done discreetly on the actions that the officers observe.
But is it their burden to put on testimony that they, is it the defendant's burden to put on testimony that they'd been there for a long time, or is it the Commonwealth's burden to show that this warrantless search was justified?
Well, I don't think it's the Commonwealth. Certainly it's the Commonwealth's burden, but it's also not the Commonwealth's burden to eliminate any, possibility or inference for what happened prior to the police arriving on the scene here, especially when they were certain about what they saw and the fact that the car was stopped and both people were in the car. So I'm not sure that the Commonwealth is required to establish, that they were nowhere else prior to being in the car, as long as we can establish that the officers believed, and reasonably so, that at that point in time, Mr. Gaines and Mr. Coleman undertook a ride to nowhere.
Well, let me put it this way. Is there any basis for thinking that this interaction between the defendant and Mr. Gaines was a brief interaction?
I'm sorry, could you?
Yes. Is there any basis for thinking that this interaction between the defendant and Mr. Gaines was a brief interaction, since we don't know when it started?
I don't think that that is necessarily part of the calculus either. As long as they saw this ride to nowhere, it happened, it was quick. They observed it the whole time. They went nowhere. As I said, they're not required to rule out every possibility and inference. I mean, even if they had been sitting there for 2 days, I'm not sure that it would matter. As long as they, from what the officers observed, they saw them drive around the block and Mr. Gaines exit and then found drugs with Mr. Gaines. So
what if the Commonwealth what if the police had spotted the Volvo, decided to watch it for a few minutes, and then they saw Mr. Gaines get out? The Volvo hadn't gone anywhere, but they saw Mr. Gaines get out and go over to the truck. Would they have,
Correct.
Would that be probable cause?
I don't know, and I'm not sure. But as I said before, I don't think there's a case that relies solely on the drive to nowhere for the conclusion that probable cause exists, to believe that a drug transaction occurred. It's just one of the many factors. And here, as we've argued consistently, it was just one of many factors to be included in the calculus. So I don't think it's really fair to engage in, what ifs in this case, because we're not, at no point have we said it's the only factor. With regard to the second issue, again,
Counsel, before you switch on to that, just one more question. What is it significant that the white pickup truck was in the driveway rather than parked on the street? I mean, if someone is visiting a neighborhood to make a drug connection, how likely is it that they would pull into the driveway of what, for all we know, is a private residence rather than waiting on the street?
Well, again, I think the fact that it was in the driveway just affects or impacts the officer's knowledge that a drug arrest had previously been made at that address, I'm sorry. So again, it's part of the calculus, whether it was on the street in front of the house or in the driveway. I'm not sure it matters. And I'm not sure, I don't have as much experience in the nature of drug transactions as these two officers, clearly. And they understood that this is a place they had made previous arrests. And so we're interested in the car there with two men sitting in it, and decided just to follow it for that reason initially. With regard to the second issue, I think that Grady is very clear that the defendant would have had to object to this testimony in order for this issue to be preserved on appeal. It's clear that his initial motion attempts to be as broad as possible, but by the end of the motion itself, he's honed in on Officer Hawley's testimony, which he was trying to exclude. Not only that, but in the calculus of whether it created a substantial risk, it's important to look at the defendant's theory of defense. And throughout the trial, the defense sought to undermine the officer's conclusion that a drug transaction had taken place. And the defense counsel repeatedly focused on whether or not the officers believed a transaction had taken place and sought to undermine their belief. So for the defendant now to cry foul and benefit from the lack of an objection now, when during trial he sought to gain from it clearly, is just not allowable and certainly not fair.
Can you just explain that? I don't understand. What did he expect to gain?
He sought to undermine the officer's beliefs as justification for following the defendant and ultimately arresting him. And focused on the fact that just because two people were sitting in a car didn't mean a drug transaction had taken place. So he sought to use the officer's testimony to his own advantage, repeated it in questions on cross-examination, repeated it in his closing, and now on appeal is trying to claim it was objectionable. So in the calculus, it's not allowed.
But wasn't counsel just trying to make the best of a bad situation? He knew the evidence was coming in. He thought it had been allowed in by the ruling on the motion in limine, and now he had to respond to it and deal with it somehow.
I think at the point that the officer's testimony came in that they believed the transaction represented that they believed it was a drug transaction, that was before Judge Nestor ruled that Officer Hawley's testimony was not going to come in.
No, but I'm not talking about Officer Hawley. I'm saying once the other two officers testified to their belief, and then it was time to cross-examine them, what was defense counsel supposed to do? Just leave that unmentioned, or say, well, what basis did you have for this belief, and didn't you jump to conclusions and so forth?
Oh,
Wasn't
certainly.
he just responding to the car, playing the hand he was dealt, in essence?
No, because it was part of his opening and it was part of his closing. So at all times during the trial, they sought to focus on the fact that these actions did not reflect a drug transaction because the officers didn't see anything. That was always their theory.
But was the focus on the officer's belief part of the defendant's opening?
I'm not positive, but I think it's, I don't think that the defense switched midstream. That is not reflected by the transcript, that he was just trying to make the most of it. When you repeatedly ask the question again and again, I mean, that's not making the most of it. That's focusing on it. So.
Can I ask you to go back to the motion in limine? I thought the trial judge precluded the recipient witnesses from offering expert testimony. I thought that was part of his ruling.
I think he precluded them from offering testimony as to the nature of a sale.
Mm-hmm.
And that's what the Commonwealth sought to have Officer Hawley testify to. And then when it was testified to, the defendant didn't object. And the judge didn't strike it. The judge didn't say anything. So it really became sort of muddled in terms of how it came out as it flowed from the motion in limine regarding the overarching decision. So I will say that. But as I said, even if we can conclude that the defendant's motion in limine preserved the issue, the error was harmless in light of the other strong evidence of the transaction and of the defendant's illegal actions. So for those reasons, I'd rest on my brief for the remainder of the arguments.
All right, thank you very much to both counsel under these unusual circumstances, and stay safe.
Thank you, you too.
Thank you, Your Honor.
Shall I begin?
I have an intro.
Sorry.
Sorry.
We are live.
Good morning and welcome to the Massachusetts Appeals Court oral argument session. Our next case this morning is 19P0982 Commonwealth versus Dennis Dilibero. My name is Justice Peter Sachs. I'll ask my colleagues to introduce themselves now.
Justice Sabita Singh.
Justice Dalila Wendlandt.
And appellant's counsel, could you please state your name and the party you represent for the record?
Elaine Fraunhofer for Dennis Dilibero.
And appellee?
That's Stacey Gothier for the Commonwealth.
Thank you. As you know, this argument's being held on Zoom and live streamed to the Appeals Court's YouTube page. I want to remind all participants to speak slowly, clearly, and one at a time. We'll follow the same rules and customs as in the physical courtroom. Each side has 15 minutes to argue. The justices will ask questions. Only one advocate may speak at a time. The session clerk will mute other advocates until it's your time to speak. The session clerk will display a countdown. The proceeding is live and being recorded. Anything said during the proceeding will be heard by all of those observing and become part of the record, just as is in a physical courtroom. A pseudonym must be used for any person's name that's impounded, and impounded information must not be disclosed, which is an issue here, as I'm sure you're both aware. So with that, I will ask Ms. Fraunhofer for the appellant to begin.
Thank you, Your Honors. I do want to acknowledge that Mr. Dilibero's wife and young daughter are watching this proceeding. Before addressing the individual issues I raised, I want to stress that in deciding whether this is a case where this court should grant relief, it is imperative not to lose sight of the fact that the issues raised here are interconnected and that they culminated in a fundamentally and profoundly unjust trial. This case is a more egregious example of the situation presented in the case of Commonwealth versus Johnson, which I cite in my brief. Johnson vacated convictions after describing a culmination of prosecutorial abuses that in and of themselves called for vacating the convictions, but as the court explained, was a remedy that was all the more appropriate because those abuses were combined with defense counsel's failure to expose them, and therefore the defendant was deprived of his ability to present his case, the truthful case, to the jury. In Johnson, after describing what that court referred to as an extraordinary record, the court reversed the convictions, concluding the trial that the defendant received was generally unsatisfactory. In Mr. Dilibero's case, there was the added problem of a child victim whose memory of the events the evidence suggests may have been irrevocably tainted and unreliable. And so the proceedings here were not just unsatisfactory from a due process standpoint, we also cannot have faith in the outcome. All to say, I encourage Your Honors to revisit the Johnson's analysis as you evaluate the abuses that I outlined in this appeal, including that the prosecution presented perjurious testimony and misleading testimony on material issues to gain the indictment. They failed to alert the trial court judge that the indictment was gained using perjured testimony. They foisted upon the grand jury irrelevant but titillating and likely false, if not grossly exaggerated, prior bad act allegations that were against Mr. Dilibero in an attempt to whet the grand juror's appetite to indict, to derail the defense's.
I don't want to cut in on your presentation, but I did want to ask about the Odell motion and the presentation about prior bad acts. If the ADA in the grand jury had not gone on to give some of those details, the judge in denying the motion said, well, then we'd be here on another motion saying that the Commonwealth didn't present evidence that would have showed the mother's bias against the defendant. What's wrong with that reasoning?
A couple of things I'll say. I mean, I want to point out that those allegations that were introduced during the grand jury, the defense counsel at trial really went out of their way to avoid introducing, and ironically, the trial judge understood that. I think at one point, the trial judge was trying to, or maybe a defense counsel was talking about wanting to ask certain questions, and the trial judge was saying like, well, if you ask that, that just opens the door to letting in that information, which we're talking about now, these irrelevant alleged prior bad acts. And because that it was so important that the defense not, they didn't want to reveal that, they didn't go down that path that they were going to go down. So to suggest that, this should have come in, it was important to come in to show the bias. No, this was pretty, what do I want to say? It was very, very prejudicial, and it was unnecessary because the grand juror's question had been answered. The grand juror just asked, did she ever feel uncomfortable? He answered yes. And so the grand jury, I guess I'll say it's hard to imagine the grand jurors imagining anything worse than this. And I mean, it was clear from the grand jury that the mother would regularly let the Diliberos take care of her child. So, the only thing worse you could imagine was that she was going to accuse that he had, had prior history of child molestation, which clearly the grand jury wasn't going to imagine because she was regularly letting him watch her child. And so this evidence was over the top, probably false, and unnecessary. So I just want to continue what the last thing, I think it's the last thing, listing the prosecutorial abuses, to get the trial judge to allow an in-court identification where the identity of the perpetrator was a hotly contested issue and there had not been a prior identification. The prosecutor falsely claimed that there had been a prior identification procedure, and to get the court to allow the prosecutor to ask the child if there had been more than one sexual assault. The prosecutor misled the trial judge about the nature of her interview, an interview, by the way, which resulted in the child suddenly and dramatically changing his account to one that was much, much more favorable to the prosecution.
But spontaneously, according to the assistant DA in the first account. She said he just blurted it out. And then she had Detective Cordero come in and asked him to essentially repeat what he'd said. So at that point, she was asking specifically, but the first time, as far as we know, it was spontaneous on the part of the victim, wasn't it?
I'm sorry, but this is a detail that is slipping from my memory, but my memory is that there is something in the record that shows she was asking him questions. It wasn't spontaneous. But I can't, I'm sorry, that's all I can say about that. Anyway, I just want to say that list of prosecutorial abuses that I just listed, those are established from the government's own evidence. That doesn't even include all of the prosecutorial abuses that are established from the affidavits that were submitted with a motion for new trial, which were also significant. So here the situation was far worse than in Johnson, because here the prosecutorial abuses infected every single critical stage of the proceedings. So I'll turn now to the very first issue, which was the prosecution's failure to alert the trial court that perjury as to material matter was presented to the grand jury, a violation of Mr. Dilibero's due process rights under the 5th and 14th Amendment. When responding to this issue, the government characterizes it as an appeal from the denial of a motion for new trial, but this is a direct appeal and has nothing to do with the denial of the motion for new trial. In any event, while the Commonwealth doesn't directly respond to the due process issue I raised, it relies upon Commonwealth versus Mayfield and writes that the issue is whether there was a substantial risk of a miscarriage of justice. And Mayfield says that is established if, one, the evidence was given with knowledge that it was false, that it was, quote, probably significant in the view of the grand jury, and that it was presented with the intention of gaining an indictment. So in the end, I would submit that really it doesn't matter whether this court applies the Pacerto standard that I relied upon in my motion, in my appeal, or the Mayfield standard the government raises. The result's going to be the same. Here, the record is overwhelming that Detective Cordero and ADA Rudman knew they were presenting false testimony as to material issues in order to get their indictment. The government's own record establishes that after Detective Cordero's interview of Mr. Dilibero and after the child's Singh interview, Detective Cordero admitted that the evidence against Mr. Dilibero was weak, and it was. That during the Singh interview, the child had not specifically identified which papa he was referring to. He called it an accident. He said he didn't say where it happened. He didn't say when it happened. So obviously, detective's grand jury testimony that falsely suggested Mr. Dilibero was the only possible perpetrator and that the child had visually identified him as the perpetrator was material to the grand jury's decision.
Counsel,
and it's really the only.
You're free to use your time however you want, but I have a number of questions about the in-court ID. So I just want to make sure that you get to that, or I can pose my question now if you're ready.
I think I'm going to finish this because I don't have much more to say about this issue, and then I want to have you ask that question. So I will say the key question is whether the prosecution knew that the statements were perjurious, and I think the evidence, and I won't have time to go through all the ways it's clearly established that they knew. It's overwhelming. The government's, suggestion that these were all just, mistakes, slips of memory, misunderstandings, it defies credulity, especially when you consider that all of the evidence worked in favor of the Commonwealth and that all of the evidence that was false shored up the weakest parts of the government's case. And this is the final point about this first issue about the about Detective Cordero and ADA Rudman misled the grand jury that they knew that the alleged assault occurred right in the middle of the date range of the indictment. And the reason, because the government asked this, the reason the prosecutor and the detective fed the jurors this false information was because after Detective Cadero let slip that the government actually had no idea when the assault occurred, the grand jury had the power to then decide not to indict. They had the ability to do that. And that's why the prosecutor jumped in to invented this lie, like, oh, it was, the disclosure was 6 months after the incident. Yeah. And then Detective Cadero lied and swore to it. And also the grand juror's comment thereafter that, like, okay, yes, that answers my question. I know we had a year, referring to the 1 year date range of the indictment, shows that.
The terms of the indictment weren't fixed at that point, were they?
Yes. The dates of the indictment were fixed. And then, in fact, after presenting that,
in what way were they fixed? If the grand jurors had stated some uncertainty over when the period was, I mean, is there a 6-year limitations period on a crime like this? Couldn't the proposed indictment, which hadn't been voted on yet, have been amended to specify a wider date range?
I suppose it could have, but they also could have said, I actually don't quite know the answer to that question. I do know that they had an indictment that had a date range that ADA Rudman led them to believe they had evidence that it was fell within that date range, and that was false. And then they grand juror said, okay, that does answer my question. I know we had a year. So I think ADA Rudman understood that if they hadn't fed that false information, that grand jury might have said, oh, well, this doesn't fall within the date range of the indictment that we have been given. We're not going to indict. And so it probably, in the words of Mayfield, made a difference in the grand jury's decision to indict. And the government's suggestion that, well, this doesn't matter because a defendant cannot overturn a conviction because of lack of evidence of a date of an indictment, that has nothing to do with whether the grand jury can choose not to indict. I want to just stop right now and ask Your Honor your questions about the
Creighton and the ID. So Creighton says there may be good reason for the first identification procedure to be, in essence, an in-court show-up where the eyewitness was familiar with the defendant before the commission of the crime, such as where a victim testifies to a crime of domestic violence. Why doesn't that exception to the general disfavor of first-time in-court show-ups apply here?
Because if you have to read the next two sentences, because it says there's a citation after that sentence, and then it says good reason might also exist where the witness is an arresting officer who was also an eyewitness to the commission of the crime, and the identification merely confirms that the defendant is the person who was arrested for the charged crime. And then it says in both of these circumstances, referring to the situation where obviously what you just said, the in-court show-up is understood by the jury as confirmation that the defendant sitting in the courtroom is the person whose conduct is at issue rather than as identification evidence. But in this case, it is absolutely clear that the reason ADA Rudman was fighting so hard, including misleading the court about there being a prior identification, to get this evidence in is because they were using it as identification evidence.
What does that term identification evidence mean? It's used in that one sentence in Creighton, but nowhere else, and nowhere does the court define it as far as I can tell. What's your
Well, I think it's the distinction between it's not information that the understood by the jury as confirmation that the defendant sitting in the courtroom is the person whose conduct is at issue. Identification evidence, on the other hand, is evidence that says, I'm identifying this is the person who did this to me, which is exactly what they did in this case, where the prosecutor got the little boy up and said, I want you to tell me which one, even though Mr. Dilibero is the only person sitting in the courtroom. I want you to tell me which one, which is why Creighton says that's not reliable evidence if it's an in-court identification and why it needed to be excluded.
In essence, the victim testified here, that's Papa with the brown shirt. He's AD's dad. I've visited them, but not in a long time because of the disgusting thing. His private, he peed in my mouth. Isn't there a difference between he's the one I call Papa and Papa did it on the one hand, and he over there is the one who did it on the other? And he over there is the one who did it seems to me like more like an in-court show up, but he's the one I call Papa and Papa did it is more like, I know this person. I recognize him from before the alleged event. And he was the person who was there and who I'm talking about when I say Papa put his private in my mouth.
I would say that in this case, given all of the evidence showing their influence on this child, that you just can't, it's just not a safe assumption to say that those factors ameliorated the problem that Creighton establishes.
Okay. Well, your time is up. Thank you for your presentation. And now we'll hear from Ms. Gauthier for the Commonwealth. I'm sorry, I should have asked the other panelists whether they had further questions.
Yeah.
No. Okay. Ms. Gauthier.
Thank you, Your Honor. May it please the court, Stacey Gauthier.
Your mic is muting in and out.
Sorry. It's the Commonwealth's position that this court should affirm Judge Hussain's denial of the defendant's motion for a new trial and affirm his conviction. First, I would just like to make one correction in my brief on pages 41 to 42. When I was referring to the DCF records, I had stated in the Commonwealth's brief that the docket had indicated that the prosecutor would not have had access to those records until she signed a protective order about a year after the grand jury hearing. However, while preparing for the argument in this case, I became aware of General Law, Chapter 119, Section 51B, subsection K, that states that the department shall notify and transmit copies of substantiated 51A reports and written evaluations to the district attorney in the county where the crime occurred. So it does appear that she very likely did actually have access to those records at the time of the grand jury. And I just wanted to correct that.
Does that mean that she would have had the 51Bs?
This just says the 51A reports.
Okay, but the critical evidence that the defendant is pointing to, I think, was in the 51Bs.
Okay.
And I'm wondering whether you can tell from the statute whether, or anything else, whether the 51Bs would have been in the ADA's possession at the time she was presented to the grand jury.
The statute that I found just just recently, when I was preparing for the argument, that just says copies of substantiated 51A reports, written evaluations, and written determinations. And it was unclear to me, just looking at the records, whether those records were the 51As or 51Bs. But it does appear that 51A reports, at least, she would have likely had those prior to the grand jury hearing.
And you explain how that correction affects your argument.
I don't think that it would affect my argument at all, Your Honor. I don't think, just going through like certain things that were reported, I don't think that it's going to affect my argument at all. With regard to issue 1, the false and misleading statements alleged to have been made at the grand jury, the Commonwealth first would raise waiver under General Law, Chapter 277, Section 47A. Motions to dismiss that go to the indictments must be raised prior to trial, and in this case, it was not raised prior to trial, so that we'd say that by waiting until after his conviction, the defendant waived his right to object to any defects in the underlying grand jury proceeding. With regard to the merits, it's not enough for the defendant to show that false evidence was presented to the grand jury. The defendant must show that the evidence was presented knowingly or recklessly, not negligently, and not a good faith mistake. And it must be for the purpose of obtaining an indictment, and it must show that the false evidence probably influenced the grand jury's decision to indict and was material on the question of probable cause. Here, there was much exculpatory evidence that the prosecutor and Detective Cordero did present to the grand jury. The grand jury was aware that the disclosure came after the victim spoke to someone other than the defendant. They were aware that the mother, as well as the boyfriend, had been talking to the boyfriend's father on the phone. They were aware that the mother was trying to get the victim to call Bob Papa prior to the incident, and that was who was on the phone when the victim made his disclosure. They were aware that the defendant denied the allegations and that he told Detective Cordero that he could have been referring to the mother's boyfriend's father. They had been trying to get him to call him Papa. They saw Exhibit 4, which is the family photo that came from the mother's makeshift photo array. And in that photo, that went in with the handwriting on it, which is at Record Appendix 98. There's a photograph, and it says that that is Bob, and it says that the victim identified him as, quote, Papa Bob. And that went into the grand jury. That was exhibit number 4. So the grand jury, at the least, would have been aware that the victim had identified Bob as, quote, Papa Bob. Further, they were aware, again, that Papa Bob was how the victim identified Bob in the photo array. Also, in the photo array, in the makeshift photo array picture at Record Appendix 98, that shows Bob. He's standing with his hands in his pockets, unsupported by anything. He's not in a wheelchair or using a cane. So it doesn't show that he's an invalid. I know one of the arguments was that Detective Cordero testified that Papa Bob couldn't walk. However, he's standing in this picture. And I would suggest it was just a misunderstanding as to the fact that he couldn't walk, where Bob testified at trial that he had degenerative disc disease. They were also aware that Detective Cordero testified that when he talked to the defendant's wife, she said she thought that something happened to the victim, but she did not think that it was the defendant that did it. The grand jury also saw the recorded portion of the defendant's interview. In that interview, he had told Detective Cordero that the victim used to cry when he went to go see his biological father, as well as his biological grandfather. That would be at the defendant's interview. He also stated that he had no idea why the victim had made those claims. He pointed out to Detective Cordero that the victim was on the phone when he was talking to somebody else when the disclosure was made. He pointed out that the mother had been trying to get the victim to call Bob Papa for 3 or 4 weeks prior to the incident. He also asked Detective Cordero at one point, why is it me?
Yeah, I have a question, and I don't know whether the record cast any light on this, but the mother's testimony was that she had just the very day of the disclosure decided that she was going to try to get the victim to refer to Papa Bob as just Papa. Do I have that part right?
That's correct.
Okay. And then the defendant tells Detective Cordero, admittedly in an interview on August 25th, which is a couple weeks after the disclosure, that the parents of the victim had been trying to get him to do that for 3 or 4 weeks now. So I don't understand, number one, how he would know that they've been trying to get him, they've been trying to get the victim to use the term Papa. And number two, the mismatch between the timing. And does the record shed any light on that?
The record shows that, that the defendant had stated that the victim had been trying to get the mother to call Bob Papa for 3 weeks to a month prior to the incident. And that was on the recorded portion of his interview that was played for the grand jury. So they were aware that there was somebody else that was potentially, they were trying to get him to call Papa. And then the victim also identified Bob as, quote, Papa Bob in the photograph that was submitted as grand jury exhibit number 4. So they were aware that the grand jury was aware that the defendant denied that it was him. And they were also aware that there was a pre-existing bias that the mother had based on the incidents that she claimed when she was younger. So, I mean, that shows at least that they would think to maybe take what she was saying with a grain of salt.
If we can go to that issue of the prior bad acts and the Odell motion. I noticed that, as I mentioned before, the motion judge said that if the ADA had not gone on to give the details of those prior bad acts after the grand juror asked that one question, did she ever feel uncomfortable? Then according to the motion judge, we'd just be here on another motion saying the Commonwealth didn't present evidence that would have showed her bias. And that could have been used as a basis to attack the integrity of the grand jury. I notice that you don't make that argument in your appellate brief, and I'm wondering if that's because you see a problem or an issue with that.
No, a lot of, we were just, it was a very long appellate brief. We were trying to make the most concise, write the most concise brief as possible. But the judge is correct in that if they hadn't put in that she had a bias, then again, it would be likely that there'd be a motion to dismiss based on her bias, and that's not presenting that to the grand jury. With regard to the—
But didn't she go a lot farther than she had to disclose, make a fair disclosure that there was some reason that the mother could be biased against Papa?
Well, first, the prosecutor didn't put that into their case in chief. That came as a response to a question from a grand juror.
I'm a little confused about that, actually, because I know there was a break and then some grand juror questions, but the Singh interview hadn't been played yet, as I understand it. So I wasn't clear that the ADA was done with the case in chief with the grand jury.
Well, that was a little unclear. It did say that there was a pause. It didn't say that the grand jury proceedings had ended. However, she didn't knowingly initiate it. It came in response to a question from a grand juror. The grand juror had asked Detective Cordero if the mother lived with the defendant when she was a teenager, to which Cordero said yes. The juror then asked, and she never felt uncomfortable with him. And then the prosecutor at that point told the detective that he could answer the question, but they couldn't use that evidence in their deliberation. So then they elicited some prior bad acts that had been told to Detective Cordero by the mother. And I would suggest that Detective Cordero was very clear in his testimony that these are acts that he was being reported to him by the mother. He kept saying, she said, she said, she said. It wasn't that Detective Cordero was testifying that he had any personal knowledge that these incidents actually occurred.
And all that go way beyond what the grand juror was actually asking?
Well, it did go somewhat beyond what the grand juror, the grand juror asked if she felt uncomfortable, and this generally goes to her feeling uncomfortable. If I understand that the defendant feels that the prosecutor should have stopped after, Detective Cordero answered that yes, she felt uncomfortable. However, if they stopped at that point, that leaves the grand jurors to speculate as to why she felt uncomfortable. And it's quite possible that the grand jurors could have speculated something worse than what actually the testimony was. So putting in these
I don't really understand that argument, because here's a person who allows Papa to babysit the child weekly, at least, and be alone with the child. Why would it be reasonable for the grand jury to believe something worse than what was disclosed?
Well, because maybe they could have speculated that he's being accused of a sexual assault. In this case, maybe he sexually assaulted her in a prior case. That they could certainly have speculated about that. This was not a sexual assault. That it wasn't like a rape, I guess it was more specifically. It's not a rape that she was describing. So it's different than what happened in this case. So they could have speculated that it was an actual rape on her as well. Why she would leave her son with him after that, I don't know, but it's certainly something that they could have speculated. So by putting in these prior bad acts, it closes the door on speculation, because now they know exactly what the acts are, and it shows that she is biased against the defendant. So that is certainly exculpatory to the defendant.
I want to make sure we get to the in-court ID issue. And if you don't mind, I'd like to ask you the question I asked before, or we explored before with defense counsel. What does Creighton mean by identification evidence when it says there may be good reason for an in-court show-up if it's understood by the jury as confirmation that the defendant sitting in the courtroom is the person whose conduct is at issue, rather than as identification evidence. What's the distinction being drawn there?
Well, the problem that the Supreme Judicial Court was trying to address in Collins and Creighton was the risk of misidentification. And those two cases both involved victims who had never encountered the defendant before the incident. So the court held that, there's good reason to admit an in-court ID where the witness was familiar with the defendant before the commission of the crime. And the reason for that is because a witness who's familiar with the defendant is not just identifying him from that one incident while they were, while the crime was being committed. That witness is identifying the person as being the person that they knew, but prior to this incident. So the risk of misidentification in that instance is lower because the person already knows who they are and is identifying them from knowing them prior to the incident. So that's what I would suggest is the difference between, good reason for allowing an in-court ID of somebody who's familiar with the defendant versus allowing an in-court ID of someone who's never seen the defendant before the crime.
Okay. Well, your time is up. Thank you both for your presentations and stay safe.
Thank you, Your Honors.
Thank you, Your Honors.
Sorry, I should have asked whether either of you had more questions. I keep forgetting to do that.
That was good.
18P 1187. My name is Justice Peter Sachs, and I'll ask my colleagues to introduce themselves now.
Justice Sabita Singh.
Dalila Wendlandt.
Mr. Benyon, could you please state your name for the record and the party you represent?
My name is Brad Benyon, and I represent Mr. Sargent.
And Mr. Kidd?
Good morning, Your Honors. My name is Rob Kidd. I'm an assistant DA at the Bristol County DA's office, and I represent the Commonwealth in this matter.
All right, as you know, this argument's being held on Zoom and live streamed to the Appeals Court's YouTube page. I want to remind all participants to speak slowly, clearly, and one at a time. We'll follow the same rules and customs as in the physical courtroom. I know you're both very familiar with them. Only one advocate may speak at a time. The session clerk will mute the other advocates until it's your time to speak, and the session clerk will display a countdown. The proceeding is live and is being recorded. Anything said during the proceeding will be heard by all of those observing and become part of the record, just as in a physical courtroom. I feel as if I'm giving Miranda warnings here. A pseudonym must be used for any person's name that's impounded, which I don't believe is an issue in this case. So with that, Mr. Benyon, why don't you begin?
Thank you to the presiding justice, and may it please the court. The facts of this case are fairly straightforward, as is the law, I believe. This is an appeal from the probation revocation hearing. I guess I'll start with the letter. So in this case, the government introduced a letter that was purported to have been written by the defendant and sent to Mr. De Jesus, who was the previous probation officer. Mr. De Jesus never received the letter. However, it was placed in the record in his probation file, and probation officer Bancroft is the one who received it and read it. In this case, the trial counsel objected to the admittance of the letter because the government was not prepared to authenticate it. Now, as you're aware, there are a number of ways to authenticate a handwriting. Usually, you could get an expert. That's one way to do it. The expert would then compare two known samples of a person's handwriting and then testify.
Right, but here we didn't have that. So we have the content of the letter itself, the fact that it's in his file, the return envelope that's got the place where the defendant was being held, his prisoner number, his unit number, and why aren't those circumstances enough to, even if the evidentiary rules apply to probation revocation hearings, why isn't that enough to authenticate it?
Because those are readily available that's readily available information that others could get. And when we're talking about handwriting, the law at least has viewed handwriting as unique enough that a determination can be made whether the defendant actually wrote it. So oftentimes with respect to handwritten documents, the concern is with respect to forgeries. Now, in this case, each of those points that you raised is public information and could be obtained by pretty much anyone. And even some of the contents of the letter, and you'll have to remember that the defendant was, the fire that he's suspected to have started occurred on October 4th, 2017. This is a letter, it's postmarked, I don't believe the letter's dated, but it's postmarked April 12th, 2018. So this is a year later when most of the information has come out as to the offense. And, you know, I don't think it's too much to ask the government to rely on rules of evidence. In this case, it's a probation revocation hearing. And so the standard of proof is lower, right? In a criminal case, it would be beyond reasonable doubt. And in this case, it's by a preponderance of the evidence. But in either case—
Isn't the standard for authentication always a preponderance?
Well, the standard for—
Well, maybe we don't have to argue about that, but the standard for authentication, at least in this case, we're pretty sure is a preponderance. Whether the judge could find by preponderance that this letter was written by Mr. Sargent.
See, I don't know how the judge could do that because the judge was not familiar with the defendant's handwriting. Now, I think what you're talking about is whether the letter was a genuine article. In that case, the law does say that the judge makes a preliminary determination. But in this case, once you move past that, then you have to show that that you have to either have a known sample of the defendant's writing, and then you compare that with the letter that you're questioning. And in this case,
well, go ahead.
I'm sorry. You said after the judge makes the preliminary determination, then there must be this handwriting comparison that must be done?
Yes, that's what the law says. It's always been that way. Handwriting is unique that the law presumes that it can be distinguished. So what you do is you get a handwritten sample that you know is of the defendant's and you compare it. You don't need an expert.
That's definitely one way of authenticating a handwritten letter. You're saying that is the only way, in addition to the other way which you mentioned, which is that a lay witness who's familiar with the defendant's writing could then look and say, yeah, that's a signature.
Yeah. So again, as you and I were discussing, Justice Wendlandt, I was saying there were certain ways to do it. I first said that you could get an expert. You told me that that's not what occurred in this case, and that's true. But then you also get a second, or the other way you do it is you get a known sample of the defendant's handwriting. And then you compare that with the article that you're trying to authenticate, in this case, the letter. It does not have to be a handwriting expert. The law presumes that a jury or a fact finder judge can look at two samples, one that's known and one that's not known, and make a determination. Now, when the court, or when the judge, or excuse me, when the government tried to put in the letter, it said that it could put in the handwritten document. It didn't have to authenticate the probationer's handwriting, and that it just went to the weight of the evidence, and it was for the court to determine. That's on page 11 of the transcript. And that presupposes that the judge was familiar with the defendant's handwriting. What I don't like with respect to probation revocation hearings is that the standard is already lowered. And I'm not arguing that that's inappropriate. In fact, I think it is appropriate because the defendant has been released, and it's based upon their own good actions that they can remain at liberty. But when you start to lower the standards of evidence, that's where I have a problem, because we're concerned with, for example, forgeries or inaccurate documents. it doesn't seem like it was that big of a deal to get an authentication of the letter, because oftentimes we talk about the indicia of reliability. That seems to be a terrible test. It presupposes that the government or the judge has a gut instinct or a sixth sense about what is good evidence or not. And in an adversarial proceeding, we don't just determine whether evidence is good or bad, it's how it's tested.
May I ask, who besides the defendant could plausibly have known all of the details in this letter at the time it was written? Details including the only thing that was wood on the building that was burned was the stairs, and the office to the office. The stairs got burned, but not that badly, because after the fire, the state troopers used the stairs to walk up to the office. That's a detail about the case that not that many people would know. Put that together with, if you look at my record, I don't have anything on it violent till 2013. And then the letter says on the last page, I have a 7-year-old son that needs at home. He also has a learning disability like me. Who is it that the judge could plausibly think would have all of that information available to them other than the defendant?
In this case, as I said, the letter comes in 2018. By then, most of the facts of the investigation would have come to light. I mean, by then the defendant had already been indicted. But I guess my concern is that the judge never even made that determination. They really only discussed whether the government could admit it without a handwriting. But I would say each of those points that you raised, Justice Sachs, could also be gained from public record through the examination of the police file of their investigation, or from the defendant himself, who would have been aware of these points. And since it came from the prison, that might be one of the, at least that's what my client feels was what likely happened, was that a roommate or somebody who was familiar with him, who he spoke with, could have forged the letter in his stead. And again, nothing is so unique that it allows the government to just admit the letter. But there was no determination as to that point anyway. The letter was just admitted. And I think that what we want to do is—
Remind me, was there an objection?
Yes, there was an objection.
Okay, thank you.
And in this case, my client received a rather significant sentence. And so that's what I want you to understand, why we need to keep, even though the standard of proof is low at a preponderance, when we admit evidence, that still needs to be tested in the adversarial process. It can't just be through gut instinct of the judge, or that it looks or has the indicia of reliability. It needs to be tested. And when we're talking about a letter that has what could be viewed as fairly damning admissions, you need to make sure that the defendant wrote it, and that you do through handwriting. You get an example of what you know the defendant's handwriting is, and you put it in. There's nobody who was at the trial, at the hearing, who could authenticate the letter. The government hadn't obtained a known writing sample. The probation officer, Mr. Bancroft, I believe this is one of the first times he'd ever met the defendant. And so—
Would the defendant's signature on the probation quote unquote contract have been in the file before the judge?
That's not disclosed in the record. And again, there was no discussion of it. It was just admitted. There was no testing of the known sample versus the letter at issue. Are there any other questions with respect to that point? Then I'll quickly turn to the preponderance of the evidence argument. My client feels that that even though certain points could be viewed as showing or raising suspicion, the government didn't prove by a preponderance of the evidence that he was the one who set the fire. The film is grainy. It doesn't really show him. He doesn't believe that it shows him as the one who set the fire. He feels that the police, because of the events that occurred 6 years previous, were in a rush to solve the crime and just used him as a scapegoat. In this case, the police went to his place of employment. One of the police officers said they saw the car in question, the RAV4, that it didn't have any condensation on it. But we don't know if, for example, the RAV4 without any condensation, for example, was in the sun versus a car in the shade that might have been cooler that would have had condensation. He finds it difficult to believe that the police would have been able to readily identify him after 6 years. And he just feels that this was a rush to judgment with respect to solving a high-profile arson. And that's a determination that you'll have to make based on the record. You have the exhibits before you, but if there are no questions, then I'm happy to rest on my brief.
Seeing none, thank you for your argument. And now we'll hear from Mr. Kidd. You're still on mute. You're muted. Yeah.
Sorry about that. Didn't want to disturb the court. Yes, again, good morning, Your Honors. Robert Kidd for the government. So I want to address my understanding of what the law is. I disagree with counsel. There is no requirement in the law for authentication that a handwriting expert, look at the writing and determine it is the defendant's writing. There is no requirement that a person familiar with the defendant's writing do the same. Those are good things to have, but they're not necessary. The rules of evidence provide that the appearance, contents, substance, and internal patterns or other distinctive characteristics can be conserved to authenticate the letter. And that circumstantial evidence alone, I'm sorry, go ahead.
Are you familiar with any cases where a handwriting has been authenticated in the way that you suggest? That is by the circumstances surrounding the writing as opposed to comparison? There are a number
of cases that I've cited. Most of the more recent cases, as the court may know, involve email kind of electronic communications. Commonwealth versus Purdy is the main case. In that case, an email was authenticated. There's also a case that I cite, I don't remember the name of it, where their hospital records were admitted and based on some biographical information in the hospital records. And there's another case that I cited. Well, I can go to my brief if I can. I just have 1 minute.
Well, I have your brief. My question is with regard to handwriting, not emails, not hospital records, handwriting. Are you aware of any cases?
No, I'm not.
Okay.
I think that's just, I'm not. But I think that the principle applies. The principle that I just cited in the rules of evidence apply, and that circumstantial evidence alone can authenticate a letter. And that's that in my mind. There's no lack of clarity in that. There's no case law that says that cannot be the case. It just so happens that we don't have a case, that cites that rule. In this particular case, I disagree with counsel also in his brief that he interprets the judge's decision as using the reliability standard of Durling rather than authenticating the letter. Counsel objected to the letter. Defense counsel objected to the introduction of the letter on authentication grounds. The judge asked the DA, "What do you say about authentication?" And the DA said, "Here's what I say about authentication." And he went through some facts. The judge said, "Let me see the letter." And he presumably read the letter, and he came back and he said something, forget what his exact quote is. I think he said, "For purposes of a probation surrender, I'm going to admit it." Those words did not mean that the judge was not authenticating the letter. He clearly did. He asked counsel to authenticate it, and he wanted to hear from counsel. So he followed those rules. and he did so. The letter, when he read the letter, he would have learned, as I said in my brief, he would have seen the envelope that is from the Plymouth County House of Correction. He had before him a defendant who had a Plymouth County charge. He had on that envelope and that letter that he was viewing a number, an inmate number of this inmate. He had a full name of this inmate by the name of Mark W. Sargent, S-A-R-G-E-N-T. That Mark W. Sargent is listed on the probation record that presumably the court would have in front of it. So whoever wrote that letter was able to put down the defendant's correct full name, Mark W. Sargent, was able to write down the inmate number, unit number on the front of the letter. Then the judge read the letter and he would have learned that the letter, well, actually, the letter was addressed to probation officer DeJesus. So whoever wrote the letter
Let's
knew
look at, looking at the worst case scenario. What if someone from the Commonwealth who would have access to all kinds of information about the defendant and perhaps some non-public information, attempted to forge a letter that had damaging admissions in it? Why couldn't they, what part of this, what information in this letter would someone not have had access to? Who was in, for example, the probation service, let's just say hypothetically.
Yes, I mean, I suppose one could think of a scenario, and counsel maybe does, where this defendant is rooming with somebody and the person gets some personal information about the defendant and does forges this letter. But that does not mean that the letter doesn't pass authenticity, the requirements of authenticity. All that is required is a preponderance of the evidence to show that the more likely than not, it was the defendant who wrote the letter. Though what I suggest, what Your Honor is talking about, is challenging the letter on its face in cross-examination. I think in Commonwealth versus Purdy, there was sort of an analogous issue. In Purdy, the argument was, well, the defendant didn't, you can't prove that the defendant sent this email. All you can prove is that it came from his computer in his house, which the police seized. And the court said, well, that may be true, but it doesn't negate authenticity. Authenticity is a separate standard. So I think we have the same situation here. In all likelihood, and more likely than not, the person who knew who the probation officer was, the person who talked about the setting fires, the person who talked about the details of this particular case, more likely than not, that person was this defendant. And that's all that needed to be shown. So I don't have much more to say about.
Do you agree then that the formal procedural rules of evidence would apply to a probation revocation hearing?
No, I do not. And I never said that in my brief. I never addressed that in my brief. Whatever standard the court uses in this particular case to review the letter passes that standard. The correct standard is reliability, and the letter is, for the same reasons that I just stated, that it's authenticated, it is reliable under the Durling standard. But it seems to be counsel's position that the court should change this rule in probation surrenders. I disagree. I think the court doesn't need to do anything. That standard, the reliability standard, was if that was used in this case, it was not. My position is was not. But even if that was used in this case, it amounts to the same thing. I think we're talking, in some ways, I hate to use this word, in some ways it's semantics, but we are in the appeals court, so I understand that.
Any further questions from the panel?
All right.
Anything else you want to tell us, Mr. Kidd?
Well, I won't belabor the court with the preponderance of the evidence standard. I think the court, in my mind, it's a compelling and substantial case, if not an overwhelming case, against the defendant based on the evidence that was before the court. And I would just ask the court to review my brief and ask the court to deny the defendant's appeal.
All right. Thank you both for your arguments, and stay safe.
Thank you all. Thank you, Your Honors.
Right, we are good to go.
Good morning and welcome to the Massachusetts Appeals Court oral argument session. Our next case is 2019 P1305, Department of Children and Families and another versus father. This is an impounded case. Next case is 2019. My name is Justice Peter Sachs, and with me are Justices Sabita Singh and Dalila Wendlandt. Appellant's counsel, could you please state your name and the party you represent for the record?
Alan Campbell, representing the appellant father.
And appellee's counsel, could you please, in the order that you're going to speak in, state your names and the parties you represent?
Morning, Your Honor. I'm Carrie Kipp Horseman. I represent the Department of Children and Families.
Good morning, Your Honor. Sharon Sullivan Puccini on behalf of the children.
Thank you. As you know, this argument's being held on Zoom and live streamed to the Appeals Court's YouTube page. I want to remind all participants to speak slowly, clearly, and one at a time. We'll follow the same rules and customs as in the physical courtroom, which I know you're all familiar with. Only one advocate may speak at a time. The session clerk will mute other advocates until it's your time to speak. The session clerk will display a countdown. The proceeding is live and it's being recorded. Anything said in the proceeding will be heard by all of those observing and become part of the record, just as in a physical courtroom. This is an impounded case, so we need to be careful to use pseudonyms for the people involved. And with that, I will ask Mr. Campbell to begin for the appellant father.
Good morning. May it please the court. My name is Alan Campbell. It's my privilege to represent appellant father in this appeal. And I would like to start with a quick quote from the children's brief at page 7 that I believe sums up this matter quite nicely. This is a case that involves a father who loves his little boys. He has a relationship with them, and he has played an active role in their lives, oftentimes as their primary caregiver. And having said that, the first issue, excuse me, that I would like to address is that the judge erred in not addressing father's plan in the findings. DCF's plan was a guardianship with termination of father's rights. Father's competing plan, although it wasn't submitted as a paper plan, it was orally presented to the court. Father's competing plan was a guardianship with the same caretakers that DCF was proposing, simply without a termination of his rights. What father wanted was an opportunity, once he got out of prison, or jail rather, to complete his service plan and have the children return to him eventually, at least to have that possibility. Father was not.
If I may interrupt, the difference is really that DCF sought termination and the father didn't, and the father opposed termination. But as far as the guardianship, everyone was on the same page.
That was the plan put forth by both sides. Yes, there wasn't a stipulation to unfitness or anything like that, but that was the plan.
So obviously with the father opposing termination, DCF favoring it, are you saying the judge didn't give enough of an explanation of why termination was in the best interest of the children at this time?
Yes, actually, this is raised in two separate issues in the brief, issues 2 and 3, one saying that the court didn't consider less restrictive alternatives, and then issue 3, which is that the court didn't address father's plan. And when a party puts forth a plan, the court is required to consider the plan. They have to look at DCF's plan. Does it meet the child's needs? They look
but is
at
that really a plan? I guess
it is really a plan. The plan is a guardianship with the maternal aunt and uncle with no termination of my client's rights. That's a plan.
But I guess, isn't it considered in that DCF's plan was with termination, so the judge had to decide whether to terminate or not?
If you go through at a basic level, yes, that is one way of looking at it. But in going through the plans, the judge has to explain why he is going with one plan over the other. In the findings, there are findings 127 to 131 are the findings that specifically address the plan. There is no mention of simply doing a guardianship without termination. The discussion in the findings is only about a guardianship with termination. And similarly, when you go through the conclusions of law, and it's numbers 45, 46, and 47, which is actually, frankly, mostly boilerplate language. The court says the DCF has to submit a plan. Other parties have a right to submit a plan. There is no mention whatsoever of father's plan. And the court should not accept from the lower court's silence that there's a rationale that will pass appellate muster.
But I don't understand that. We're not allowed to credit the lower court's silence, but we're supposed to say that father submitted a plan in silence.
He didn't submit a plan in silence. I don't have the transcript cited in front of me, but it's at the very beginning of the trial, and I'm sure I cited it to it in my brief. At the beginning of trial, father's counsel gets up and tells the court what he's looking to do. That's a plan. I mean, to require him to submit a document that says, I'm sorry.
Even at the end of trial, it was specifically mentioned, correct?
Yes.
This was part of the summation. I believe father was pretty clear.
Yeah, I would agree that father was very clear.
So the judge actually.
I'm sorry, I didn't hear a question.
Yes, it seems that the judge at the end of trial engaged with father's counsel on this argument about to terminate guardianship with or without termination. That was specifically addressed. The judge engaged in that.
But in the findings, where the court, lots of things happen at trial, but the findings is what this court looks to. That's where makes the factual findings. That's where the judge makes his statements of what the controlling law is and where he makes his ultimate decision. The findings is what allows this court to consider what the lower court did and to see whether or not it was an abuse of discretion. And the findings are absolutely 100% silent on the possibility of doing a guardianship without terminating father's rights. And especially where one child is 4 and the other is 15, that is an issue that needs to be addressed, because it's entirely possible that had the court gone through the rationale, the court may have said, as for the older child, termination isn't necessary, and then perhaps for the younger child it would be. I mean, the child is 15. He's been raised by this individual for years. As quoted from child's brief, he was oftentimes the primary caretaker. 1 month after the children were removed, the court investigator wrote something to the effect of, based on the older child's presentation, I assume that he had been subjected to good parenting at some point in his life, if not in the present. There was a connection. I understand the visits didn't go well, but and that there's a reason for that, which we may address later. But this is father's plan. And the findings are totally silent. There's not a word to father's plan in the findings.
You would agree that
there was
the
a finding that termination was in the best interest of the child.
Yes,
correct?
There are findings regarding DCF's plan, but there is not a finding that says something to the effect of, I'm aware that I don't need to terminate parental rights to reach DCF's plan. However, for the following reasons, I still believe that it's in the child's best interest to terminate. That's an issue that really needs to be addressed, since that really was the crux of this trial. There was no question father was unfit. He was serving the end of a one-year sentence. So at the end of trial, he could not take the child home that day. And again, I hate to belabor the point. There are findings regarding DCF's plan. There is no finding as to why father's plan was inappropriate. No problems with it. No indication that the court actually gave it any consideration.
Does it have to be explicitly labeled and addressed as the father's plan versus merely, and I shouldn't say merely because there are very important interests at stake, whether termination was in the best interests of the child? So isn't really the question we're faced with here, did the judge, obviously aware that the father favored guardianship without termination, make sufficient findings regarding how termination was in the best interests of the children?
I believe under Hugo and Lars, the court needs to make findings on every plan that's proposed. Father proposed a plan, there are no findings on it. It's an abuse of discretion.
So if we find that this isn't a plan within the meaning of Hugo and Lars, and I believe there's a statute that governs plans as well, isn't there, in consideration of plans?
I would assume so. I don't have the site directly in front of me, but I know Hugo and Lars are the controlling law.
But if we don't consider this a plan, I mean, when we see in many of these cases, a plan involves a different nominee caretaker, whether it's an adoptive parent or a guardian instead of an adoptive parent, or whatever it might be. This does not fit the traditional definition that I'm aware of plan, and I don't know if you have a case that says that this sort of alternative that the judge was faced with constitutes a choice between two different plans, but I'm not aware of any.
I don't know if there's a case directly on point defining what a plan is, but this, whatever it would say, unless it required a written document, which I see no reason to have father submit a document that says, I agree with DCF's plan, except for the termination. The plan is there's an two identified individuals, maternal aunt and her husband. They've been caring for the children for some time. Father believes that they're doing a good job raising his children, and he's perfectly happy to have them, the children, remain with those caretakers until he can get himself together, get out, do the services that were asked him to do once he got out. And then at some point, again, he could perhaps seek custody again of the children. But that is a plan. There's no aspect of the plan that is lacking by him saying, I agree with DCF's plan, except for the termination. I mean, what else would he need to say? Does he need to write down the same information that the court already has in front of it? That seems to be really putting form over substance. The plan was there. Again, it wasn't introduced as an exhibit. But frankly, I don't know if the statute actually requires that the plan be submitted as an exhibit, just the plan be submitted to the court, and the court can consider it. And
You'd
again,
agree that the judge could weigh the children's need for permanency, stability, predictability after the amount of period of uncertainty that they had faced. So you agree, though, those are permissible considerations in deciding whether termination is warranted.
Those are permissible considerations, but
are you saying the judge didn't give enough attention to those here?
Again, we have a 15-year-old and a 4-year-old. There is not a single finding or mention in the conclusion of law what they need or why obviously every child needs stability. So to just say it's going to be decided by stability, and that's why, that would essentially make trials meaningless, because children all need stability. Nobody's saying that they don't. And frankly, that's partly why father wanted to have the same maternal aunt and uncle be the caretakers, because he wanted the children to have continuity, while he continued to work on his parenting ability. But the findings are silent. And I'm sure, actually, I'm not even certain that I am, but I wouldn't be surprised that the word stability shows up someplace in the conclusions of law in a boilerplate section. And there is no reason, especially as to the older child, there is nothing in the findings or the conclusions of law, the rationale, as to why a guardianship with maternal aunt and uncle would not provide this child stability, given that he's 15. And it's only 3 years before he reaches adulthood. It's entirely, to assume that something would happen in those 3 years to cause the guardianship to disrupt if father wasn't fully capable of parenting him is purely speculative.
Wasn't there a conclusion that the father's unfitness was likely to last into the foreseeable future, even if he got out of, was released from incarceration?
Well, there is in every termination case that's ever come before this court. But I would actually, there isn't a specific finding to that. There is one of the factors the court considered was that the unfitness was likely to consider. However, if you look at the history of this case, there has been a long period of DCF involvement, off and on, I believe, for almost 15 years, which you might on first blush say, oh, that's terrible. But the reality of it is, every time DCF got involved, father did what was asked of him. He got his skills together. He became sober. I mean, he struggles with sobriety, but he's had periods of sobriety. The children were always returned to him. This is the first time that they were permanently taken, 15 years in. And I don't want to make crazy assumptions.
Can I ask, I don't read your brief to challenge the sufficiency of the evidence as to termination. Is that correct? That's not one of your issues.
It's not, this isn't a sufficiency case. No, it's at the court. I'm sorry, did I cut you off? No. No, this isn't, we're not saying there wasn't sufficient evidence. We're saying that the court didn't pay close attention to the evidence that was before it and didn't consider the competing plans and didn't consider less restrictive options of whether or not they would have survived, whether or not that would have also met the children's needs. And if there aren't further questions on that, I will just very briefly touch on the other issue, is that a new trial is required because of clearly erroneous findings of fact that were central to the ultimate decision. I'm not going to go through them in detail because they're all laid out in the brief, but the basic crux of it is father was not asked to do any services according to the action plan while he was in jail. The social worker did testify that she asked him to do substance abuse, verbally asked him to do substance abuse while he was in trial, but she didn't put that into the action plan. The action plan was he only had to do services upon release, and he wasn't going to be released until the month after trial or 2 months after the trial was released. So all of the references in the conclusions of law to father not taking advantage of offered services, it's clearly erroneous. He wasn't asked to do anything, and he did do something. I mean, he did he did actually do a little bit of work on substance abuse while he was in jail. He did substance abuse, relapse prevention, healthy relationships, anger management, small engine repair, and then a program called After Rec, which isn't explained in the record. In the bulk, I believe it's 4 or 5 of the factors rely on that when he hadn't been asked to do anything. He was also faulted for where the social worker wasn't able to verify. The social worker testified she never asked him what he was doing. She testified that she never asked him to sign a release. So she wasn't able to do it because she didn't try to do it. Hold it. Oh, I see my time is up.
Yeah, I wanted to ask one more question. Even if the judge misstated whether the service plan called for the father to engage in services while he was incarcerated, what reason is there to think that the father will engage in and complete any services once he was released from incarceration, and that he would be able to stay out of jail? So in other words, might there be a harmless error issue here?
Not in this case, no, because this was central. It's really central to the termination, I believe. Father has a long history with DCF. He's done what they ask of him. The children weren't removed. He has his problems. He's been very candid with his problems and openly admitting that these are his problems. And he says he's going to work on it. He has in the past in jail, even though he had access to limited services, and the service plan or action plan, I guess we're now calling it, didn't require him to do anything. He actually did do some work. There really is no reason to not credit father when he says that as soon as he gets out, he's going to work on these things. He had been doing that for years. And he'd have, it's a case where he'd have a good periods, then bad periods. Unfortunately, this trial came very quickly. It was less than, I believe, less than a year, or only 13 months when the case was brought on. That's very quick. Unfortunately, he had a short sentence that happened to coincide. I believe he was arrested 2 weeks after the children were removed, and then he was in for, it's a 1-year sentence, but the way it works, you don't actually do the full year, as you probably all know. He was released the month after the decision came down. And actually 5 months, his release date was 5 months before the judge found he's been convicted of a felony that's going to keep him from being able to parent his children for years, which at the time it was written, it was false. As far as the record shows, he was out 5 months before the court put in his findings that this felony conviction is going to keep him away from his children for years. It's the judge simply did not pay attention to the record. And
all right, unless there are further questions, I think we need to leave it there. And we'll hear from Ms. Kip Forsman. Am I correct? You're going first for the department?
That's correct, Your Honor. And the appellees are splitting the time evenly in half between the two of us.
Thank you.
May it please the court. In this case, the trial judge did properly consider the father's position. As Your Honor pointed out, father's position, which was, please don't terminate my rights, does not constitute a plan pursuant to the case law when the case law addresses what an alternative plan is. Under Hugo and Lars and the petition case cited by the father in his brief, those are cases where a parent presented an alternative plan, meaning a completely separate caretaker, a separate household, even maybe a separate state. That's an alternative plan. Don't terminate my rights is an opposition. And that's what this whole trial was about. The whole trial was about whether to terminate his rights. So all of the court's findings, 25 pages of detailed, specific findings reflecting close attention being paid to the evidence, all of those findings speak to whether or not termination was in the children's best interests. The SJC in the case
But they mostly deal, excuse me, they mostly deal with fitness, don't they? Rather than why termination per se is in the children's best interest in terms of need for stability, predictability, permanency, and so forth. And I think that's what the father is pointing to. No specific discussion of why termination was necessary.
Well, in adoption of Nancy, the Supreme Judicial Court said that the findings regarding fitness are, you know, inextricably interwoven with what is in the children's best interest. Specifically, the court said a trial judge need not specifically state the reasons why termination of parental rights is in a child's best interest. That can be implicit in the findings of fact and conclusions of law. And in fact, that was the case here. In addition, the court did explicitly mention that termination of parental rights was in the children's best interest here because of their need for stability and permanence. In conclusions of law 39 and conclusion of law 43, the trial court specifically acknowledged we don't have to terminate parental rights. It's not a prerequisite to approving a plan of guardianship. But in this case, under these facts, it's warranted because these children, after 15 years, in the case of the older children, deserve permanence and stability, something they did not have while they were in the care and custody of their parents. And all of the findings that speak to the children's instability while with their parents, all of those findings don't just speak to current unfitness, but they also speak to why it is so imperative that these children have stability going forward.
Ms. Kipfortsman, may I just stop you there and let our session clerk know that at least on my screen, the timer has frozen at 6 minutes and 15 seconds.
Yeah.
And I see nods from the others indicating the same. So I'm not sure how long it's been there, but my guess is for a little while since you started with 7 minutes and 30 seconds. Why don't you just pause until we get the timer back on track. And I'm hoping that the session clerk can hear us.
I can hear you.
Okay.
One moment. I'm just going to stop recording for 1 second.
All right. Just announce the case again.
right. We are back online and we can resume.
Thank you. All right. We are, can we set that to 5 and 30 seconds, or I'll just add on the 30 seconds. All right, we're resuming the argument in 2019 P1305, Department of Children and Families versus Father. Ms. Kip-Forsman.
Thank you, Your Honor. I think when we left off, I was going to ask the court to turn your attention to another case in addition to the Supreme Judicial Court's ruling in adoption of Nancy, holding that specific and detailed findings regarding why a termination is in a child's best interest are not necessary. I would also ask this court to look at a more recent case coming from this court called Adoption of Zarina, Xarina. And in that case, the facts were somewhat similar in that a parent argued that a child's needs would be equally met in a guardianship without termination of parental rights. This court held, in affirming the lower court's decision, that in fact, a guardianship without termination of parental rights does not provide a child with the stability and permanence they may need. And so it is with the case before us. Indeed, without the termination of parental rights, father has the opportunity to initiate multiple repetitious litigation going forward and to interrupt and interfere with the children's lives. He has the opportunity to receive notice of any proceedings regarding the custody of the children, including the guardianship. He could petition for removal of the guardian. He could petition under Chapter 119, Section 26 for review and redetermination of the children's needs. All of this would continue a disruption in the children's lives. And after almost 15 years of instability living with the father, these children, as the court correctly said, deserve and need permanence going forward. The comparison of the children's condition and the comparison of their lives prior to being placed with their aunt and uncle in 2017 is stark. They lived with father, who has a 25-year criminal history. He's a drug dealer. He's a drug user. He has been using substances since he was 12 years old, and he is an admitted heroin addict. He continued to use drugs right up almost until the time of trial, even while he was incarcerated. He tested positive for cocaine. He tried to smuggle drugs into the jail. And as a result, he was often shackled. He was in segregation, or in the hole, as he described it.
Positive test was right after he was incarcerated, wasn't it? It wasn't clear to me whether that might have been a vestige of use immediately before his incarceration, or whether it actually reflected use while incarcerated.
It's a bit unclear about the date. But he was disciplined for trying to smuggle drugs in, and he was the subject of a disciplinary report as a result of that positive test. In addition, the children's lives when they were with father were also riddled with instability based on the fact that the father is a batterer, and he has not addressed his pattern of perpetrating domestic violence. There was even an instance where the older child was caught in the crossfire and also suffered an injury. And the father was charged with assault and battery even on the child in addition to the mother. Last, the children were horribly neglected while they were in their parents' care. At the time they were removed, the home was infested with cockroaches. There was a live cockroach in the baby's bottle. There were dogs that needed to be restrained, feces on the floor, pit bull in the bedroom. And these children are happy where they are thriving. The older child, who used to go to school fatigued, smelling of cat urine, dirty, is now receiving straight A's, and he's a double Dutch champion. He's in Boy Scouts and he's happy. He does not want to see his father. It's, I think, as the quote in Adoption of Hugo, it's a success story in a world where there are few. And I would ask that this court affirm the lower court's decision that these children need and deserve the permanence and stability that comes with a termination decree. Thank you.
Can I just ask?
Sure.
My understanding was that this is, am I correct that this was deemed a guardianship rather than adoption because of some financial issue on the part of the guardians?
There is some discussion in the record that was the reason that it might have been a guardianship rather than an adoption. It's not completely clear, but the landscape around subsidizing guardianships versus adoption has been shifting a lot in the past few years. So I know there was a discussion about the finances, but I don't think the record is clear as to why the goal was guardianship rather than adoption.
Okay, seeing no further questions, we'll hear from Ms. Sullivan Puccini for the children.
Puccini on behalf of the children. I was appointed in this case to do oral argument. I did not write the brief. The children asked this court to uphold the juvenile court's decision terminating father's parental rights. The father had, as just discussed, had an extensive criminal history of drug dealing with guns out of the home. The children were present during drug raids when the father was arrested multiple times. There was a pattern of domestic violence that they witnessed. One time, JT was hurt during one incident in 2011. Father failed to address domestic violence and his drug issue problems. He did have periods of sobriety, but he did relapse several times, including right at the time of removal. He had repeated incarcerations that made him unavailable to these children, unavailable to provide stability. The judge was correct when he said that there was a toxic, the parents had a toxic relationship, which turned into a toxic environment for these children. There was 13 years, JT's whole life, that these behaviors have not been addressed by father. He did not ameliorate all the different behaviors that affected his children. Now the DCF plan with his maternal aunt and uncle and his grandparents, maternal grandparents live upstairs as well, is in the child's best interest. And I just want to point out that at one period when father was incarcerated for a gun charge, the child lived with mother and with maternal aunt for a period of 3.5 years. They are now in a stable, safe environment that they love. Social worker testified that they are thriving and they are bonded with the guardians. JT has identified the guardians as his future parents and the home as his forever home. And even father acknowledged that the children were in a good place. There's been talk of the stability and permanence for these children and why termination is necessary. And I think a quote from Adoption of Nancy is important. It is only fair to the children to say enough. There has been behaviors going over and over with the father that has affected the children, and termination was proper. It was in their best interest. Turning now to visitation, father has requested.
A question about termination is, I mean, you mentioned years and years, but for the younger child who was younger, there was no, that I saw, any differentiation. Do you have a position on that?
Well, he was present in his short little life, present during domestic violence, during the drug raid. The removal is horrendous, what happened to these children. DCF went in and the children were present and they were trying to find father, and family members had to be called so that the police who went with DCF to arrest the father so that they could go in and that the children were not present. They were there living in horrendous conditions, that poor child. And he doesn't even know his father. He's not bonded with his father. The family that he knows, his parents, are the present guardians. If there's no further questions on that, I will turn to visitation.
I had a question about visitation at the outset.
Sure.
It seemed to me that at trial, the children's position, at least the older child's position, was that he was in favor of some visitation. Now, I don't know if you're permitted to answer this based on the rules that govern representation of children, or whether you're able to answer it because, as you said at the beginning, you've come into this case recently, but can you tell us why the child's position has changed?
So I did look into this of what happened at the trial. Children's attorney at the end, at the closing, I think is what you're talking about, Your Honor. Yeah. He says, in my opinion, there should be visitation. But it's throughout the record, which I did comb through to make sure I did see his position on visitation was throughout the case. Older child did not want visitation. He said it in March of 2000.
He doesn't want to go to jail. Wasn't that really it? He didn't want to visit his dad in jail.
No, it was also that he did not want visitation. If you look in the DCF reports, the March 2018, he told his father, he told his social worker that he didn't want visits. After that horrendous visit at the jail, he didn't want visits after that as well. But also in the guardianship plans, which are Exhibit 12 and 54, there's discussion about what he's talking about with his counselor, and he specifically says in there that he's not is not wanting visits. So I think there seems to be some confusion, but in the children's brief, the position is at the time the brief was written is that the children do not want visitation with father. I also want to point out in the children's brief, which I think is a misstatement because it is not supported by the record, that the father was attached to that the child JT was attached to father. There's no indication in the record. The record establishes that he was afraid of father. He told the social worker that he was afraid. He said, he's tough on me. And he tells me that I disappoint him. He did witness domestic violence and himself was injured. And again, he didn't request visits during the case. So there's no bond between JT and then TT, there's no bond as well. His father was in and out of jail, and the guardians are the only ones that he knows. Again, the one visit that they had, granted it was through plexiglass, the child was too young to interact, but even that one visit JT was nervous to go to. He tried to bring an agenda to discuss with his father about how well he was doing. He was proud about how well he was doing in Boy Scouts, how he was doing in school. The father was talking about parole and about why his mother had not visited him, and the social worker had to redirect him, and then JT shut down. On the way home, he cried and he said, "This is not a happy place and I'm not sure if I want to go back." But other than that, he did not ask for visits throughout. Both children are bonded with the guardians. They are in a thriving, stable home that they love. And again, so that's the best interest, that visitation should not be ordered. But the guardians are also entitled to the presumption that they will act in the children's best interest. Again, if I would point to Exhibit 12 and 54, where the guardianship plans do state that the guardians are supportive of visits as long as the father would be sober and it would be a safe environment, so long as it's not harmful to the children. And the judge, in finding that visits were not warranted to be ordered, did not abuse his discretion. Then I ask that you uphold the juvenile court's decision if there's no other questions.
I wanted to ask one question about your last point. You said the guardians were open to visitation as long as the father assures the boy's safety. Citing Record Appendix 1 at 289. I looked at that page and I didn't find anything there that supported it. So I'm wondering whether you can tell me whether I'm missing something or.
So it's Exhibit 12 and 54 in the guardianship plans. And I could send to you the correct site because I do think some of the sites were off and that I could correct them in a letter. But I know that the father did argue in his brief that the guardians, there's no evidence that guardians were supportive. Well, they're entitled to the presumption, but there is in Exhibit 12 and 54 specifically that the guardians are supportive.
Okay. If you could send us the correct sites in a brief, I think we'd appreciate that. Yeah. Is 10 days sufficient for that?
Sure, I can get that right out. Thank you.
Thank you. All right, thank you all, counsel, for your participation in arguments this morning, and please stay safe.
Thank you.
Yeah.
Thank you, Your Honor.
We are live.
All right, good morning and welcome to the Massachusetts Appeals Court oral argument session. Our next case is number 2019 P1534, Jacqueline Sabogal versus Derek Bruce. My name is Justice Peter Sachs, and with me today are Justices Sabita Singh and Dalila Wendlandt. And appellant's counsel, could you please state your name and the party you represent?
Yes, good morning, everyone. My name is Richard Reed. I represent the appellant, Jacqueline Sabogal.
And Mr. Bruce, can you identify yourself for the record, please?
Yes, good morning, everyone. My name is Derek Bruce. I'll be self-representing.
Thank you. All right, as you know, this argument is being held on Zoom and it's live streamed to the Appeals Court's YouTube page. I want to remind all participants to speak slowly, clearly, and one at a time. We'll follow the same rules and customs as in the physical courtroom. Each side will have 15 minutes to argue. The justices will ask you questions during the argument. Only one advocate may speak at a time, and the session clerk will mute the other advocates until it's your time to speak. The session clerk will display a countdown timer. The proceeding is live. It's being recorded. Anything said during the proceeding will be heard by all of those observing and become part of the record, just as in the physical courtroom. This case is partially impounded, so let's be sure and use pseudonyms where necessary to protect privacy. So with that, Mr. Reed, representing the appellant, I'll ask you to begin.
Yes, good morning, Your Honor, panel, Mr. Bruce. My name is Richard Reed, as I said. I represent the appellant, the mother. This is an appeal of a judgment that modified an existing shared parenting plan. The parties are the parents of Madison. The parents of a little girl who just turned 3 years old at the time of the modification judgment. The modification judgment significantly reduced the time that the party's daughter spends with her mother from a shared parenting plan to 3 out of 4 weekends per month. This appeal challenges this judgment in its entirety, as there was insufficient evidence to limit the little girl's time with her mother, to change legal custody, and to award father-child support. This is because the court failed to take into consideration the traumatic effect that occurs when a child's parenting plan is altered. Such a change will necessarily affect the happiness and welfare of the child, especially one so young who does not understand why she cannot see mommy as much as she had before. I'd like to address from the very beginning some issues, especially those that the court found most offensive as far as the evidence that was presented by father at the trial.
Mr. Reed, could I interrupt you and just ask you a couple of what may be housekeeping questions, but could be significant. Your record appendix table of contents says that there's a transcript of proceedings from July 20th, 2018 at pages 45 through 48. But they're not there. There is no transcript there. What's there is the answer and counterclaim to the complaint for modification. Are we missing a transcript that we should have, or was that just a typo in the table of contents?
That may have been a typo in the table of contents that was prepared prior to the submission of the transcript, which was submitted as a separate document.
Okay. And the other question, and this may be a little more substantive, excuse me, the finding of fact number 3 at Record Appendix 191 refers to the parties' stipulation of facts. And I see 2 stipulations of fact filed just before trial on the docket sheet. We don't have those in the record, either of the stipulations. That may not be material, but the reason I ask is that the finding says, the stipulation says the mother works at Bristol Community College in Fall River. But then the finding number 9 on the same page, Record Appendix 191, says the mother now works in Boston. So, and I think that's material to the reasons for the mother's move to Millbury, at least as she testified to them. So can you tell us which is correct, and do we need to have the stipulation to work out whether this finding is supported or not?
To my knowledge, she works in Fall River. At the time of the judgment, she works in Fall River. Her employment did change from time to time. I believe perhaps the court was mistaken. There were a few mistakes in the findings of fact. If the stipulation would help provide some further information on that regard, I'd be happy to supply it. But as far as the decisions that led the judge to decide the findings of fact, or the elements or the facts that led the judge to conclude as she did, the relocation that was provided by, the reasons for the relocation provided by mother were the proximity of her new residence to her place of work compared to where she was before. I think regardless of whether it was Boston or Fall River, considering that Fall River is close to Millbury, provides insight as to the fact that it was actually in Fall River.
So yeah, if the stipulation will shed any light on where she works, and to your knowledge, I don't want to get too far outside the record, but where does she work currently?
Currently, I am not sure exactly where she works. My involvement in this case is strictly with this appeal and the review of the trial record.
Okay. All right. Well, I think we're familiar with the facts, so why don't you jump right into the most important part of your argument?
Thank you, Your Honor. As far as the most offensive elements of the case is interpreted by the court in this case, the father produced a video that the child's mother had sent to him in support of his argument for a change of custody. The court disapproved of this video. There is nothing in the video to suggest that any abuse is occurring or that Madison suffered in any way. Nothing is said other than Daddy's girlfriend's name. Remember the circumstances of this case, that one of the father's complaints is that mother had introduced too many significant others to the child too soon in their relationship, while he denied having introduced a significant other to the child. Yet somehow the child knew the girlfriend's name. This was all mother was trying to show, and by father's testimony, mother advised him to watch what he says around Madison, around the child, because she absorbed more than perhaps maybe he realized and restated it. The mother's not stating that Daddy's
couldn't the judge take into account the propriety of having the child on a video repeating the name? Isn't that the point? Not so much that the child knows the name, but the judgment there in having the child videotape saying the father's girlfriend's name.
She's not telling her that Christina, the person's name, is a bad person. She's not saying that Daddy did anything wrong. She's not saying that Daddy's a bad person. She's not comparing the girlfriend to Mommy.
There's a bunch of things that she's not doing, but what she is doing is videotaping the daughter saying this name. And is it unreasonable for the judge to say, that it is a poor parenting decision?
Perhaps it may be reasonable to think it's a poor parenting decision, but it's not enough to change custody.
Of course, there's more though, right?
There's more. There is some more. The other is the elusive prescription. Miss Sabogal, I'm sorry, I keep repeating the names. The mother.
Those names aren't impounded, so that's fine. It's really the child's name, as I understand.
Okay, thank you, Your Honor. The mother tried to involve the father for the entirety of an incident involving a health emergency for the child. She invited him to participate in the examination by joining her in the examination process. He declined for want of funds. She took it upon herself to take Madison to the doctor during father's parenting time. That was a concern of hers. And then tried to fill the prescription on her way to Madison to the child's drop-off with the father. Unfortunately, the pharmacy did not have the medicine ready. If they had, this would not have been an issue. But she decided instead to bring the child to father. She then decided that she learned that the prescription was available. She went and received the prescription from the pharmacy. This is a situation of almost like the Keystone Cops situation, where you have multiple parties involved, the doctors, two pharmacies, and two parents all communicating with each other or trying to communicate with each other as to where to pick up this medicine. Whereas mother's intention from the very beginning was to involve the father and to bring the medicine to the father with the child. Through no fault of her own, it did not happen.
Counsel, I see that you're objecting on hearsay grounds to consideration of the note from the physician assistant, Michael Rao, I think his name is, and perhaps, I'm not sure, objecting to some of the father's testimony about this, but are you challenging any of the judge's findings regarding this incident as clearly erroneous?
Her findings are based upon a hearsay record, and I believe that she simply took father's point of view as the way of things happen. But there are multiple perspectives going on, which is the problem with the note in the first place. You have several people involved, all of whom with different perspectives. No one has any idea who spoke with whom and said what, and all happening within a very short period of time.
So I'm looking at footnote, I'm at finding 7 on record appendix page 191, which addresses this issue. And I'm wondering if you can tell me which part of that finding is, in your view, inaccurate or unsupported by the record, because I want to be clear about what findings you're challenging and what findings you're not challenging.
I think the summary of paragraph 7, while on its face is correct, I don't think goes deep enough into the issue. You have,
so including the part that said mother called, after father called and had the prescription moved, mother called and had it moved back to Beverly, that's correct?
That assumes that mother knew the father had called the pharmacy in the first place. There's no evidence that she was aware of this. She did not, as far as the record is concerned, from at least mother's perspective, she tried to have the prescription filled at Beverly. Perhaps, again, we don't know what was said between the pharmacy and the mother as far as where the pickup was going to be. Her intention was to pick it up in Beverly. That's where she thought it was going to be made available. She didn't understand why it possibly would be moved to another location. We don't know what she knew or what she didn't know. We don't know what father knew or didn't know. We don't know what the pharmacy knew or didn't know, which is why the note in and of itself is insufficient.
The finding that she had it moved back to Beverly is clearly erroneous.
I think that's, again, assuming that she knew that father had moved it to Drake it so that he could pick it up. Her intention was to have it picked up in Beverly, where she was told and informed and believed that it would be filled. She had already tried to fill it. She'd already been to Beverly and provided them with the prescription. And she thought it was just a matter of time that it would be picked up. And she was going there to do so and then deliver it to the father.
So other than that finding, the two I see you challenging are first that mother moved to Fall River, not Millbury. And I do see a number of places in the judge's findings she refers to Millbury. Then there's one place that she refers to Fall River. That may be just kind of a scrivener's error. She'd heard some testimony about working in Fall River, but most of the testimony and most of the places she addressed this in her findings, she recognized that the mother had moved to Millbury.
Yes.
But the other finding you're challenging is that the mother offered no reason to move except to be with her boyfriend or fiance. And you're saying there were two other reasons. One was to be closer to her work, which she said was in Fall River at the time.
Yes.
And the other was to be closer to a doctoral program, which from the context seemed like it was in Rhode Island, but I couldn't find anything else in the record about that. Can you shed any light on that?
I believe that might have been in Boston. I know she was doing a postgraduate study in that area. She also was doing a doctorate program. I'm not sure, based upon the record, exactly where that was located. I do know that it was a perfect situation for her. It was proximate to where her fiance was working in Connecticut. She did not seek to move to Connecticut. She was trying to stay within a place that was easily accessible to father. She did not want to interfere with father's parenting time. She did not want to change it in any way. She provided information to father indicating that the travel time was about the same. Post-move, father's punctuality improved.
I want to ask about that travel time. I know she furnished some Google Maps with directions and times showing that they were roughly the same. And the father was asked whether the travel times, as shown in a couple of texts, were roughly the same. And he said, yes, they were, but he said, if you'll allow me to explain, it's not really that way. And then he didn't get a chance to explain. So the judge found that the travel time to Millbury could be up to an hour and a half. Is that clearly erroneous? Are we compelled to conclude on this record that the travel time is the same to Beverly and Millbury?
Well, there's no evidence to support otherwise. The evidence seems to suggest that the travel time is comparable. Mother's intention was trying to keep it comparable so that there was no interference with father's time. And again, her motives, I guess if you're considering Yanis, her motives are entirely genuine. I'm sorry, Your Honor?
I thought that there was testimony that the father testified that on one or two of the days, I can't remember if it was a Friday or a Monday, that depending on traffic, it could take an hour and a half.
It could, and it could also, it could take an hour and a half also from Drake to Beverly or to her area where she was living before. The traffic in that area.
Clear that there was no evidence. That's discounting what the father testified to.
Correct. And it could be a little bit longer depending upon traffic. But again, only with reduced time, I just want to hit some points here. In order for a change of custody to occur, there has to be two findings: that a substantial change in circumstances has occurred, and because of the substantial change in circumstances, a modification of prior judgment is necessary and conducive to the best interests of the child. At no point does the court cite that the change of circumstances or a significant change of circumstances had occurred. The original judgment, remember, has to be deemed correct and made with the best interests of the child in mind. The trial court did not find that there was a change of circumstances and stated that mother's move to Millbury complicated the parties' ability to share physical custody, but there was no evidence of that. What exactly did Madison experience because of that move to Millbury? Did she enjoy an improvement in quality of life, being in a situation where mother is more comfortable, perhaps maybe with additional travel time? Is that enough to justify a change of custody? I don't believe so. I don't believe the appellate court decisions in the past would support that. There is no evidence that mother, even if all of these allegations against mother are considered true, is that enough to change a child's time with her mother? There's no evidence that mother was an inadequate parent. We don't know. There was no evidence as to what effect, if any of these allegations between mother and father affected Madison. Everything is based upon speculation and conjecture. And there are considerable instances in father's brief, and I believe that father may attempt to do this as well inadvertently, perhaps during his oral argument, that he refers to matters both prior to the original judgment and post this judgment. My time is up.
All right, thank you, Mr. Reed. And Mr. Bruce, we'll hear from you now.
Good afternoon, Your Honors. The first thing I just want to say, due to the brief time, is that I have written down some of the stuff. So if it looks or sounds like I'm reading, it's because I am. The first thing I want to address is the clearly erroneous standard as far as Fall River and the Millbury discrepancy. I don't think that is, substantial enough where that could be considered, a harmful error. There's no ground for reversing the order based off of that alone. And my problem is seems to be one of the biggest points for the appellant, but that's not the only reason. And if you look at the judge's rationale, she specifically states 4 of the reasons. One of them, the mother's living situation is less stable than father's. And I think she's on her 5th or 6th house or apartment now. She's been couch jumping with boyfriends with Madison in tow. And she's only ever known one home with me.
Yeah. Let's try to keep the child's name out of the.
Excuse me. I apologize. And the second point is that if not for the boyfriend, mother would have no way of supporting herself. That in and of itself is an issue. If you can't support yourself, how are you able to support a child? And it should be noted that a few weeks after this order was put into effect, she requested basically full relief of her financial responsibilities. She couldn't afford $118 a week was her claim. And if you can't afford $118 a week, how are you going to support a child? And third, the mother has made decisions based solely on her desires to make things harder on father. And if you look at my supplemental appendix, page 31 and 32, there's the doctor's note that was spoken about, and a relative correspondence from the mother. In the doctor's note, the very first line that's underlined, it says the patient's mother had stated that she did not want the prescription sent to CVS. That shows intent. Doctors don't ask, do you not want it sent here? They don't ask that. She specifically went out of the way to say, do not send it to Drake, knowing I was on my way to Drake with my daughter to pick up the medicine. And the appellant just stated that there's no way to know that she didn't ask for it to be sent back to Beverly, but it was already at Drake. I had moved it to Drake because that's where I was headed. So how else would it have gotten to Beverly? Because I didn't move it.
I wanted to ask
Sure.
about the rationale given by the judge. And this is I'm looking, it's the last page of her findings and rationale. And she does seem to place a lot of emphasis on the distance being too great, and her finding that the mother gave no reason to move to, whether we consider it Fall River or Millbury, other than to be closer to her boyfriend. But there is clearly in the testimony evidence from the mother that she moved for two other reasons. One is to be closer to her work, which she said was in Fall River, and the other she said was to be closer to her doctoral program, which she implied was in Rhode Island. So where the judge has said a lot turns here on the distance being too great for the parties to continue shared physical custody, and there's no, in essence, the judge says there's no good reason for the mother to move other than being close to her boyfriend and maybe to make it difficult for you. But the mother did articulate two other reasons. The judge might not have been required to believe what the mother said, but if she wasn't going to believe it, should she not have said, mother offers some other reasons, but I don't believe them, rather than say, mother offers no reasons? Because that leaves us wondering whether the judge fully absorbed the mother's testimony and gave it full consideration before deciding this distance is too much, and it's the mother who's in essence going to pay the price.
Okay, I have two answers to that. The first is, we're there for a custody hearing, and while she should be taking our personal schedules into consideration, it shouldn't be the controlling factor in determining where custody should be placed. Madison's best interest is the controlling factor there. And secondly, Madison, our child is going to be in public school. So given the distance and given the hostile relationship admitted by myself, the appellant, and the judge in her rationale, there's no reason why custody shouldn't be one way or another. It's just, the only question is left is who's the best suitable option. And I think that the mother has shown a pattern of negative actions, and they can swear up and down that this excuse here, this excuse there, but when there's a pattern, I believe that shows one of two things. It shows intent or malice, or it shows cluelessness. And either way, that's dangerous for a child, especially in their tender years. And as far as me, there's nothing in the record to say that I haven't shown anything but a good pattern, being a good dad and taking care of our daughter. So that's what I have to say about that. I don't think that the judge specifically took her schedule fully into consideration, nor do I think she should have, over our daughter's best interest. But another example of the third point is that the mother has made decisions based solely on her desires to make things harder for me is the pickups. And when they were in Millbury, I would drive her there and she would pick her up and drive right back the other way, right where I was coming from. It's like, why couldn't you just co-parent with me? Or I've even talked to her about it and she's denied it. No, this is where drop-off's going to be. So now Madison's in the, now our daughter is in the car for upwards of 3 hours. And that's not conducive to her being comfortable. It's not.
I was looking in the record for an explanation of why the child would need to continue to go to school in Beverly if the mother has moved from Beverly to Millbury. I didn't see anything in the record, but I haven't absorbed it. Maybe I overlooked something. Is there anything in the record? I don't want you to get outside of what's in the record before the judge, but is there anything in the record that tells us why she would still be having to travel to Millbury for daycare or preschool when the mother lives in Millbury?
That I'm unsure of. I mean, I don't want to speak for the mother. I personally feel that her boyfriend at the time, he worked in Connecticut. It's easier for them. The commute's easier. She works in Fall River. It just seemed easier for her. She had no regard for how far Madison and I were going to be from each other. And I feel like that is the big issue is her concern. Her concerns came first.
So just on the travel time issue, I asked mother's counsel a little bit about this, but the mother did offer some evidence that the travel times were the same, and she, mother's lawyer at trial, asked you, well, based on these texts that I'm showing you, don't they don't they indicate that the travel time from Dracut to Beverly and the time from Dracut to Millbury are about the same? And you said, yes, but if I can explain, and I wasn't clear whether you were disagreeing that the travel times were the same, or particularly in light of the Google Maps evidence that was offered, or where, I mean, the judge found that your travel time could be an hour and a half, could be, but not, she didn't find that your travel time to Millbury was necessarily regularly greater than what your travel time to Beverly would be. So what can you tell us based on what's in the record?
Sure. So based on what's in the record, I believe I testified about my work is that I would drop her off in Millbury. I work in North Reading, Massachusetts at the Postal Service. I would drop her off in Millbury and I would have an hour ride back, and that affects my job. So that's what I was talking about there, I believe. And also so
your hour and a half reference is to your total travel time to Millbury and then back to North Reading?
You know, total, it would be upwards of 3 hours. In a vacuum, if you just look at the Google Maps, it's 2 hours, 10 minutes, 15 minutes or so.
So what is the 1.5 hours that the judge is referring to in her findings?
So what the judge is referring to is the drive from Dracut to Millbury on certain instances. You know, I've traveled an hour and 45 some days, and sometimes it's been 50 minutes. You know, it all depends on traffic, accidents. It's all highway. So
sure, but there's a lot of highway to Beverly as well. So unless I'm mistaken, the judge didn't make a finding that travel time to Millbury was regularly or predictably longer than travel time to Beverly.
Not that I know of, no. But the problem is she's still too far away to be able to share 50-50 and have her in the public school. It just doesn't make any sense, a practical sense, why she would live 50-50 in now North Grafton, where she lives, in Dracut, and then still be able to go to a public school consistently. It doesn't add up. And again, like I said, that's not the only issue. It's the other issues. And the biggest issue is that we're unable to communicate regarding simple issues. And like I said, the appellant said it best on page 25 of their brief. He states, and he's citing a different case, but he does link it back to us. He says, as here, the parties had significant difficulty in communicating with each other at the first trial, and that had not changed by the subsequent trial on the modification. And it continues on page 26 to say, mother and father have long demonstrated and testified to continuing strife between them pertaining to matters involving Madison. Now, if you take that and you combine it with relevant case law, and I'm speaking specifically Rolled v. Rolled 1981, it addresses this exact issue. It says that the best interest of the children are to be promoted, and when the parents are at odds, the attainment of that purpose may involve some limitation of the liberties of one or other of the parents. The personal hostility between the parents and their inability to cooperate or agree on proper child rearing practices precluded an award of joint custody. Now, there's a lot of reasons, as I said, why she lost custody. It's not just this. She's shown a pattern to put the child's best interest in the back burner. Whether that be to get at me, or make things more difficult for me, or just for her convenience.
Mr. Person, can I ask you?
Sure.
When you brought this motion for modification, initially you didn't request any change in the custodial situation, correct?
Correct.
How soon into this did you start to seek a change in custody?
So I don't know the exact dates, but I do know 6 months before the trial, I had requested it. I put it in the attorney, the trial attorney was aware, and they never made the argument that this was not raised in the original pleadings. And Civil Procedure Rule 15B states that when an issue not raised by the pleadings is tried by the parties express or implied consent, it must be treated in all respects as if raised in the pleadings. And that aside, I mean, if you just look at things that she's done, I think that it justifies me actually requesting 100%. I think that it was necessary, and I avoided it at all costs. And you can see that throughout the record. I've avoided it at all costs. I wanted 50-50. And I even, at one point, you can see it in the transcript where I asked her, have you ever come into this court asking for 50-50, or has it always been 100%? and she stumbled on the question. This is the only time I've ever asked for 100%, and I only did so because I thought it was absolutely necessary due to the withholding the medicine, the video, bribing our daughter with food to say things, you know, albeit it wasn't negative, but it's still, it shows a pattern that she's willing to do this, and that she's willing to send it to me without issue, and to not think that it's a problem to do that. And the other thing is, he brought up that I did bring up DCF has been contacted twice on her, once before this court order and once after. As recently, I had the letter, November 27th.
We don't want to, I think it's fair to confine our argument today to what was in the record before
Sure, I can do that.
Trial judge. Yeah.
Sure. And what I have to say about that is, excuse me 1 second. It's the judge's duty to not only consider what has happened or the present welfare of the child, but probable future. And if you bring that pattern into it, and she was right in making that determination because of what I just brought up, the DCF and all that, but it's not stopping anytime soon. And I feel that I've given Madison stability and consistency on a level she's never had it. She's going to school now, she's learning, she has friends, she has teachers that she loves. She's not in and out of hospitals anymore and doctor's appointments unnecessarily the way that she was with their mother. She's happy, and despite the mother not being happy, that doesn't equate to this being a fault in law. That's just how I see it. She's happy, she's healthy, and I've been more than accommodating with the mother to, if Madison is uncomfortable at any point, to give her an extra FaceTime here or there. It's just, I think that the appellant is trying to take a small issue and turn it in and make it seem like it's a big issue. It's a candle fire, really, but they want it to look like a house is burning down. And Madison has not been negatively affected. If anything, the positivity has come out of this. And I fully am committing myself to continuing that. So thank you. My time's almost up. Thank you very much for listening. Stay healthy. I appreciate you listening. Thank you.
Thank you to both parties. And Mr. Reed, I think we would appreciate it if you could send in those stipulations that were, there are two of them that were docketed, I think numbers 252 and 253.
Your Honor, the stipulations were never provided to us. They were submitted, I think, in a trial. I just checked with the trial attorney while Mr.
Really?
Bruce was, yeah, they were just submitted to the court and that was it.
Okay. Mr. Bruce, do you have copies of those stipulations, which are numbers 252 and 253 on the trial court docket?
I certainly can look. I don't know off the top of my head, but what number did you say that was? I'll write it down.
It's stipulations numbers 252 and 253, and I believe they were filed on the day of trial, which was April 2nd of 2019. It's, if you look in the record appendix that the mother filed on page 16, it's at the very top of the docket sheet. There are two docket entries called stipulation of the parties.
Okay, I will look into that. I don't have it on me. I'm
sure.
Sorry.
Well, if you could let us know within 10 days by a letter to the clerk whether either submit them or say you don't have copies of them, one way or the other, the panel would appreciate it.
Okay, thank you very much.
All right. All right, thank you both for your arguments.
Thank you. Fred Burkholder for Doe 46.
Just a sec, Mr. Burkholder, before we do that, we want to go on the record and then a couple of things. I need to call the case and so forth.
Okay.
We are live and on the record.
All right, thank you. Good morning. Welcome to the Massachusetts Appeals Court oral argument session. Our next and final case for the day is 2019 P0692, John Doe number 4693 versus Sex Offender Registry Board. My name is Justice Peter Sachs. With me today are Justices Sabita Singh and Dalila Wendlandt. Appellant's counsel, could you please state your name and the party you represent for the record?
Fred Burkholder for Doe 4693.
And appellee?
Oop.
Let's do that one more time. I think you were muted somehow.
Morning, John Bossé for the Sex Offender Registry Board.
Thank you. All right, as you I'm sure you both know this argument's being held on Zoom and live streamed to the Appeals Court's YouTube page. I want to remind all participants to speak slowly, clearly, and one at a time. We'll follow the same rules and customs in the physical courtroom, which I know you're both very familiar with. Only one advocate may speak at a time, and the session clerk will mute the other advocate till it's your time to speak. The session clerk will display a countdown. The proceeding is live. It's being recorded. Anything said during the proceeding will be heard by all of those observing and become part of the record, just as in a physical courtroom. This is an impounded case, so I just remind the parties, as you're accustomed to doing, not to use any names and just use pseudonyms. So with that, I will ask Mr. Burkholder to begin for the appellant, John Doe.
Thank you. May it please the court. First issue, of course, and main issue to discuss today is whether or not the motion for funds that was filed on behalf of Doe 4693 complied with 803 CMR 1.164A12, which in essence requires the identity of a condition or circumstance special to the sex offender and explain how the condition is connected to his or her risk of reoffense or level of dangerousness. My esteemed colleague has done a wonderful job of pointing us directly to a case which has addressed this very issue, and the evidence which is necessary, unfortunately, was not in my favor, but I'd like to distinguish that case, and maybe it'll take me to the argument that I'd like to make. That case is SORB 2883. It was an appeals court case decided by Judges Milkey, Brown, and Messing on June 1st, 2015. In that particular case, and I'm quoting from it, it states, the only medical record that the plaintiff submitted to document his diagnosis was an emergency room intake form from 2016 that listed bipolar and depression in the past medical history screening section. Nothing in that form established that the plaintiff suffered such issues at the time of his sex offenses or suggested a causal link between any such condition and the offending. The difference between what occurred in that case and what occurred in my case is contained within the two documents that were submitted in support. The first document was the December 21st, 2016 report that was submitted on behalf of my client, drafted by Massachusetts Department of Correction, and it was Ms. Knox. In that document, which you all obviously can read, and I'm not going to try to repeat, it makes it very clear, as the hearing examiner acknowledges, that my client suffers from three major conditions. And we all know.
Mr. Burkholder, can I just cut in there and say the record that he suffers from those conditions is there, but what I didn't see in the motion for funds made to the hearing examiner, which I understand you didn't file, was any specific reason why a better understanding of his mental health issues might result in a different or presumably lower classification. The hearing examiner did not end up relying on the mental abnormality factor, factor one, or otherwise rely on the mental health issues as bearing one way or another on Doe's risk of reoffense, degree of dangerousness, and so forth. What did the motion say would have been the value or relevance of an expert?
It didn't, and that's the problem. The problem leads to the second argument, which is the ineffective assistance of counsel. Sadly,
then what have you shown on this record that motion could have said?
Well, I mean, there were a number of things that I would have done if I were trial counsel. First of all, in the decision, Commonwealth versus WWW, in the last page, there is the following. It says, here the records show the defendant had a long and intensive history of substance abuse, had suffered from physical abuse at the hands of his stepmother, was the victim of sexual abuse by his mother, who initiated sexual relations with him at the age of 14, had a personality disorder, had a psychological imbalance, had behavioral problems since he was 11 years old, had made numerous suicide attempts, and had ongoing psychological treatment, including medication for depression, that was being treated with at least 4 different medications at the time of the plea hearing. In support of his motion, the defendant submitted affidavits from Ronald Ebert, Joseph Doherty, both doctorates in psychology. None of that was introduced.
Well,
It
the
certainly could have.
decision was before the hearing examiner, right?
None of it was before the hearing examiner. And
No, the decision itself. I thought the decision was submitted with the
the
motion.
decision itself was, but the basis for it and what I've seen done in the past, and I've done myself, that works in these cases, or at least gives you a better chance, is the following. You approach the client and you say, are you in fact suffering from these conditions? Secondly, if you are, how are they impacting you? Third, you're taking medications. Are you having any significant impact from the medications? Are you suffering from loss of libido? Are you suffering from loss of sexual interest? Are you suffering from any other difficulties? That was not presented. I've also introduced affidavits before from Dr. Sala, who will come forward and say, and he's one of the, I'm sure you've heard his name many, many times, and you've seen his testimony and reports, who will come forward and also say the same thing.
What we don't know, it seems to me what we don't know, Mr. Burkholder, is what they would have said had you asked them. We don't have the defendant, I'm sorry, not the defendant, Mr. Doe saying, well, he doesn't file an affidavit, and I don't think you even assert in your brief without record support, which I'm glad you don't. You know, I could have testified that I'm experiencing a loss of libido due to the medications I'm taking, or you don't have an expert saying someone with the conditions that Mr. Doe has been diagnosed with is at lower risk because of those conditions. Now, of course, I haven't examined Mr. Doe, and I can't specifically opine about him, but that's the kind of thing that could have been put before the hearing examiner had counsel been effective. So in other words, even if we're asking about the prejudice prong of Safarian.
Well, maybe I can answer it in this. Certainly that's not there. First of all, just to sidestep for a second, my counsel, opposing counsel suggests that the issue is moot under Zinsser. I'm going to suggest it is not. Prior trial counsel was also Superior Court counsel. The case law is very clear. I'll give you the citation if you wish, that says that you're entitled to a meaningful consideration of ineffective assistance of counsel, and you can't receive that if you had the same attorney at both levels. That just is Leno 409 Mass 1. It's a 1990 case. So that takes me to where I am now. So the next question is, why didn't I ask for leave to file a motion to vacate? I think it's undeniably clear here that something more could have been done. That's why I submitted, and although I know the court dislikes submitting additional evidence, that's why I submitted the one very brief study that addresses this issue. And if I may direct the court's attention to that study, it says as follows. And this could have potentially answered the question, because my argument is not only that he suffered from that impairment. He was doing fairly well up to 2016. Then he gets transferred to the residential treatment unit. And when he gets there, he doesn't do as well as he had been doing in the past. His dangerousness issues, I stand moot. Obviously, there is a serious issue with respect to his dangerousness based upon what's occurred. But as we all know, you've got to satisfy three prongs. You've got to satisfy risk of reoffense, and you also have to satisfy the need for publication in a level 3. Submitting dangerousness on its face, we come to the issue of recidivism. This guy only has one offense. It was 24 years ago. He has no subsequent conduct whatsoever, and there's an explanation for why he did what he did. He was having a severe substance abuse problem at that time. Since then, he admittedly had some problems in the institution, but those ended in February of 2000. In August of 2010, when he was arrested, or he received a D report for accumulating his medication. From that point forward, by his own testimony or his own statements at transcript page 135, as of 9/28/2010, he became sober. So now we have the question of, how do I tie it together? This study states as follows. Furthermore, co-occurring conditions such as substance abuse disorders, psychopathy, and personality disorders, which are related to violence in the general population, are also the most valid predictors of violent behavior. Evidence suggests that the most reliable a priori factors for sexual recidivism in the general population, the number of prior offenses, deviant sexual preferences, and psychopathy. Again, there is no evidence of, other than this one isolated offense, that anything occurred, and it's been 24 years ago. Now, my esteemed colleague also points to the case of 94637 and says, well, there's case law that says that's not enough. In that particular case, there were 5 more restraining orders taken out by different women. So my argument is basically this. We needed an expert to show what was current. We needed an expert. By my client's own admission, he said, listen, I was given Ativan, Klonopin, and Valium while I was in the institution. I couldn't control myself on those medications. Take me off of those medications and I would be in a different situation. So my point is it's a complex situation with this guy. Anybody that has that amount of psychological history and that amount of abusive behavior while in the institution, and there's support that says certainly that can be the cause, but he's doing well and then something happens. So my point is I think that this is just a little above what a hearing examiner could evaluate. And that's what I would have done. I mean, there were a number of things that a hearing examiner, or not a hearing examiner, but a psychologist could have looked at. What's the interrelationship between substance abuse or otherwise? Why did he commit the offenses in the first place? Is he being properly treated even for the diagnosis? The last 2 diagnoses didn't occur until 2015. So, you know, we don't know what's going on with this guy. And I think that he's entitled to have those issues evaluated. And I'm sorry, I just don't think a hearing examiner, although very learned, and we defer to their expertise, can tackle something as complex as this. And that's my problem with what occurred previously. Ineffective assistance of counsel is a difficult argument. I know that. I know that you would have loved to see a motion for leave and a motion to vacate or a new hearing. If you know me and the practice that I have, I do that in other cases. I have several pending right now. I just thought this was so blatant and there was so much there. I mean, this guy was treated back starting in 1987. He was treated, I'll find it here in a moment. He was treated for substance abuse back then, and there's evidence of it. He says in there, and it's in his own letters. Between you and me, if you read just the letters that occurred between him and his mother, you've got to have a question with regards to how that impacted this particular offense. The last thing I'm going to talk about is this. With regards to issues of dissemination, it'd be very difficult for me to make an argument that that wasn't warranted on a level 3 with this nature of offense. However, we have a very limited target pool, and we have a very, very old offense. And we have no explanation as to how anybody else other than his mother, whom by the other members of this very court have said there was some quasi relationship between the mother and him. So dangerousness, yes. Maybe even publication, yes. Risk of recidivism, I just think we need to explore it more. And whether it be a motion to vacate that's filed after this or addressing it now, I've never seen anybody with this bad of a psychological history that didn't get fees. I asked for fees where it simply said the man suffered from bipolar and he committed these offenses and fees were granted. This own hearing examiner granted fees. And then all of a sudden she decided to change her mind. I don't think that's enough. I think she abused her discretion, and I think this gentleman's entitled to fees for funds. I have nothing further. Thank you. Unless, of course, you have many questions that I'm going to hear.
I'd like to ask, what is the better way to raise a claim like this? Should you not file a motion with us saying, please give me leave to go back and file it, in essence, a 60B motion, I suppose, with an affidavit, making some kind of proffer that a better submission to the hearing examiner could have made a difference, not just kind of speculation. I mean, we've read the record. We recognize that Mr. Doe has very significant psychological issues and a very, very troubled history. But to find ineffective assistance, we need to know somehow that offering more to the hearing examiner would have made a difference in terms of showing that an expert could have given useful testimony about risk of reoffense, degree of dangerousness, or perhaps even value of dissemination. And that's what's missing here. So, you know, and we can't find those facts. So isn't it better to seek a stay of proceedings here or file a 60B once you get the case, rather than, I mean, what do we do here? Do we say the record doesn't clearly disclose ineffective assistance, so we don't reach it? Or we say, well, you just haven't shown ineffective assistance, so that claim fails? Do we leave you free to go back and file a 60B? What are you?
Well, here's the problem. Here's the problem with the 60B. All right. As indicated, I have several that are pending right now that stay was granted. The problem here is coming up with the evidence. To be able to approach Dr. Sala or anyone else, we need funds. And those are not cheap evaluations. Like I've said, I've been successful in the past getting Dr. Sala to write a very vague, ambiguous, but generalized statement that says, this is what I see. But it's difficult for us otherwise to have subpoena powers available to ask for funds for that to be obtained. So I really don't have it. If I'm going to file a motion for 60B, I'm going to need a new hearing before I can issue subpoenas to then the other doctors. We run into the same problem that we have trying to secure medical records. I have had to advance funds myself for other cases where there's been reclassifications because the doctors won't cooperate and the people don't have the money. So I just thought this case was blatant enough for the court to look at it and say, send it back, give me the subpoena powers, give me the authority to have a doctor evaluate it. I know it sounds like the cat trying to catch its tail, but that's my problem, is how do I get there from here? Because when I present it back to a Superior Court judge, they're going to look at it and say the same thing that you're saying to me now. Where's your basis? And I've got no basis for subpoena powers at the Superior Court level. I've got nothing. So I'm left with an affidavit from the client whom, frankly, although it's not in the record, I met as part of our performance requirements and responsibilities. He's doing what he's supposed to be. And that's the only other thing I want to mention with regards to Mr. Boss's argument. And I love arguing against John because he does a great job. And he points out one particular thing, and that is this guy's on probation, but there's no conditions. There are conditions. The conditions are psychological, drug, and alcohol counseling for 10 years. And as indicated, I've met him. This is not the same. The person that I met is not the same person that is here. So
are the conditions in the record?
Yes, they are. They're at page 52 of the transcript. It's in the sentencing from the original offense.
Okay. All right. I think we need to leave it there. Thank you, Mr. Burkholder.
Thank you.
Mr. Bossing.
Morning. Can everybody hear me?
Yes, we can.
Okay. So sorry. Thank you. Justice Sachs, if I could just pick up on your question of whether it's SOAB's position that the ineffective assistance claim was waived, and it's SOAB's position that the good counselor from Boston should have asked for a stay in this court and litigated the ineffective assistance claim in the Superior Court. And because that did not happen, the argument has been waived.
Well, that might be the more efficient way to do it, so that if there has to be an appeal from a ruling on a 60B, it could be consolidated with the appeal on the merits. But is that the only way to do it? I mean, the usual rule is we don't review ineffective assistance claims that are presented based solely on the trial record, which in essence here would be the record of administrative proceedings. And we don't review those on direct appeal. And here there hasn't been a motion for new trial yet. So is there something that precludes him from going back and filing a 60B other than the practical problem Mr. Burkholder points to of needing funds to get an expert to make a threshold showing that an expert is needed? Why can't he go back after this proceeding and file a 60B?
Well, with the court's permission, he could, but I don't believe that it would be successful because the hearing counsel for Doe was competent. She filed a motion for expert funds that was supported, demonstrating that this individual does have a history of mental illness, and she supported that with DOC medical and mental health records.
But you'd agree, wouldn't you, that she didn't draw a specific connection between how his mental health history affected him and how it would relate to his current risk of reoffense, degree of dangerousness, and need for dissemination. In other words, she said, he's got a lot of issues, but she didn't say, and an expert could show that the particular issues he has will somehow decrease his risk of reoffense, degree of dangerousness. There wasn't that sufficient proffer.
That's correct, Your Honor. It was a general motion for expert funds, but I don't know what more hearing counsel could have done on behalf of Doe, because despite these mental health issues and receiving adequate medical and mental health treatment in a secure facility for 23 years, Doe engaged in persistent, violent, and antisocial behavior. And so as a result, any expert testimony that if Doe were to engage in psychiatric treatment and were to properly take his medicine, that would lower his risk to reoffend and degree of dangerousness would be highly speculative, because once again, despite receiving mental health treatment, he continued to engage in violent and antisocial behavior with numerous.
I have a question, because your brothers just said that that kind of behavior ended in 2010, and so there's this gap. Can you address that?
Sure, Your Honor. Actually, the behavior did not stop after 2010. There was a record from a medical doctor that around 2016, Doe was compliant with his medicine and intended to stop him from engaging in the violent and antisocial behavior. So that was in 2016. Nevertheless, in 2017, Doe continued to engage in this violent and antisocial behavior. For example, he received a disciplinary report for fighting another inmate, and he also received a disciplinary report for breaking and trying to eat a television. And in that DOC medical record, they noted that Doe was engaging in bizarre behavior of uncontrollable laughing. So although there was an indication that the medicine was helping him around 2016, it didn't help very long, because he continued with the misconduct in 2017. Additionally, there was no evidence that upon his release from prison, that this individual will have stability in the community through housing, personal finance, as well as medical treatment. All of his, the only evidence of this was based upon Doe's self-representations. Additionally, Justice Sachs, there was a mention by opposing counsel that this individual is subject to probation conditions. However, my reading of the record is that this individual was originally sentenced back in 1995 and received a split sentence. However, because of the disciplinary issues in state prison, that probation was revoked in 1997. As a result, there's no indication that this individual is on parole or probation.
So do you agree that as far as the record shows, Mr. Doe has been sober since 2010?
Since 2010, and I apologize, Your Honor, I don't know if that's accurate, because I do know that in state prison, he received numerous disciplinary reports for unauthorized use of medicine, snorting medicine. So I would have to see when he received his last disciplinary report for unauthorized use and snorting of medicine. But there's certainly a history of substance abuse because of the role that drugs and alcohol played in Doe's governing sex offense, as well as the numerous disciplinary reports that he received for unauthorized use of medicine and snorting medicine.
Well, here's what concerned me. If it's correct, and I glanced at the D reports, and I'm not sure I saw any after 2010 that were specifically related to substances, but we'll obviously look. But if that's correct, then factor 9 says a history of abstinence should be considered. That factor 9 is obviously substance abuse. A history of abstinence should be considered in determining the weight given this factor. So if in fact the record shows that he's been sober since 2010, which was a period of 8 years or so until the time of the hearing, the hearing examiner nevertheless gave factor 9 full weight, where it seems like by the term of the factor itself, there should be some mitigation if he'd been sober for 8 years. So what can you tell us about that?
Sure, Your Honor, and you're absolutely correct. If there's no evidence that he's had substance abuse issues after 2010, the hearing examiner should not have given full weight to factor 9. She should have given it some weight in light of no evidence of substance abuse issues after 2010. Nevertheless, it's SORB's argument that full weight given to factor 9 did not prejudice Doe because of the overwhelming evidence of Doe's risk to reoffend and degree of dangerousness. In other words, the hearing examiner properly considered a number of statutory and regulatory factors besides factor 9, and after balancing all the factors, properly classified Doe as a level 3 sex offender.
Mr. Burkholder pointed to an interesting problem, which is how do you make the threshold showing necessary to get an expert? And does that in and of itself require some expert funds? Having been with the board for quite a while and seen a lot of these cases, what's your perspective on that?
Well, in this case, the offender would have had to put forward competent evidence that his history of mental illness correlates with his risk to reoffend and degree of dangerousness, and that he had a treatment plan in state prison, as well as a treatment plan in the community that will realistically lower his risk to reoffend and degree of dangerousness. But he could not demonstrate that he had a treatment plan in prison as well as in the community because of his ongoing disciplinary issues. So that would be my response to that, Your Honor.
What about the argument of publication that your brother made regarding the sole victim being the mother?
Mm-hmm. Well, the SORB's argument is that a public safety interest does warrant internet publication of Doe's registry information, because if his alcohol and drug abuse in 1993 could cause him to commit an egregious act of sexually assaulting his own mother, and because Doe made no significant progress in prison because of his disciplinary issues, he wasn't able to participate in sex offender treatment or substance abuse. So as a result of there being no stability for Doe in the community, we believe that a public safety interest warrants the dissemination of his information to protect vulnerable members of the community from being subjected to a contact offense. In other words, you know, there was no evidence that his substance abuse is under control because he never engaged in any substance abuse treatment. And if his substance abuse is not under control and his mental health issues are not under control, then the board believes that there's a high risk to sexually reoffend and put vulnerable members of our community at risk of being subjected to a contact offense.
Seeing no further questions.
Your Honor, thank you. The SOAR will rest on its brief.
All right. Thank you both for your arguments, and please stay safe. And that concludes our session for today.
Thank you.